of the client, I want to withdraw this case with a liberty to file a appeal in the appropriate forum.
This is B. Thakuria,
NS
NS Thakuria, learned counsel for the petitioner upon instructions is to permitted to withdraw the writ petition and to file appeal
Appeal
in the matter.
in the
So,
appropriate forum.
in the appropriate forum, there is allowed, matter stands dismissed on withdraw with liberty as straightforward.
Obliged mind.
May it please your lordship. My lord, I beg to mention this item for motion on Wednesday. my
Prayer
lord.
for listing, please give it to the court master. All prayer for listing,
Fine.
he may have to make some adjustments.
May I please- Obliged.
I filed an application for vacating interim order. May
Yeah.
I please your lordship. My lord, I have instruction, lordship, I beg to mention item number 8, lordship, to withdraw the petition with the liberty to file a case.
8,
8, lordship.
okay.
I suppose
The,
pardon mistake.
Upon instructions, Mr. K. Mazumdar, counsel for the petitioner, seeks to withdraw this petition and to approach the court again. Here is allowed, understands dismiss on withdrawal with liberty as paid for.
May I please,
Much obliged, lordship.
may I please your lordship.
Yes,
My lord, I beg to mention item number 56, supply, my lord. This matter may be taken after 2 weeks, my lord. As per the order of the Lawajima court, my lord, I have to take the assist service upon the respondent number 7
okay. On respond number?
for the petition, my lord. For the petition, I am for the petition.
No. You have to take steps on whom?
For the respondent number 7, my lord.
7 has already appeared. Mr. S. P. Das name is shown in the cause list.
Lawajima court matter, my lord.
No, I don't know in the cause list it is shown that it is, he is appearing. Look at the cause list.
Then, my lord, it may come for admission, my lord.
You ask, we will take it up after some time. You ask Mr. S. P. S. P. Das whether he is appearing or not. Ask S. P. because here also there is a problem. Steps you can't take like this because the address is not there. You have not given address in the cause title. Look at the address. You have not given any address. So we can't permit you to do it. I will search for Mr. S. P. Das and come.
Obliged, 23 of this daily cause business. I have instructions to withdraw this petition.
23.
Admission.
Okay. Upon instructions, Mr. A. Ganguly, counsel for the petitioner. Six to withdraw this petition, prayer is allowed. Standing counsel for Excise Department is present. Matter is dismissed on withdrawal.
Lordship, I beg to mention item number 43. Kindly take it on the Thursday, Lordship, if convenience to this court. Bail hearing matter, Lordship.
Okay. You don't want to do it today?
Lordship,
You don't want to do it today?
yes,
When?
Thursday, Lordship, coming to day after.
Then wait on Wednesday, 16th. 17th, I'm not taking up.
No issue, Lordship. 16.
List on 17. 8/2023, I paid for the loan counsel for the petitioner.
16.
16.
16.
16. 16.
High double.
Please, your lordship. I beg to mention item number 12. With due consent from Corporation Council for the Corporation Department, my lord. Lord, kindly pass over the matter for the day. I have some personal difficulty to conduct.
Counsel for the day, I paid for the loan counsel for the petitioner. Okay.
May I pray for listing on 30th, my lord? 30th of August.
You said Passover for the day?
Of like,
Yes.
Wait, please, your lordship. I beg to mention item number 33 with the consent of the Ajit lordship.
33.
Yes, lordship. Kindly matter may be taken up to 2 weeks, lordship, enabling us to file affidavit.
Okay, both sides are represented
Lordship.
on the prayer made by Ms. S. Kempright, standing counsel for KAC. List after 2 weeks to enable her to file affidavit in opposition in the matter.
Objection.
Also, I beg to mention item number 26 and 27. I am on behalf of A.Y. Sodri. He is out of station, Your Lordship, for his some personal difficulty. A prayer for adjournment of these two items, Your Lordship, for
Okay,
7 to
26,
10 days.
27, just after a week as paid for by the counsel for the petitioner.
Objection.
Okay,
Hello.
Daily list item number 1 for Mr.
May I please, my lord?
issuing a notice,
Hello.
apartment notice subject to outcome of the writ petition.
My lord, there is another writ petition, my lord. Notice may be issued and this matter will be taken with.
No, without, what you call, without service on the private respondent.
No private respondent here.
Just one. Just one. Acha, okay.
I was allowed to sit in the interview, my lord. My order dated 7/8/2023, my lord. Another petition, my lord. I was allowed to sit.
I am counsel for the petitioner. And Mr. T.J. Mankar and senior counsel, assisted by Ms.
P. Sharma.
P. Sharma, counsel for APSC representing responding numbers
2, 3,
2 is personal department. I think 3, 4, and 5.
sorry.
3, 4, and 5.
5. C, 4,
and
5.
Yes, M. Bhattacharya, Leonard, additional senior government advocate, appearing for respondent number 1 and 2. If you notice a motion returnable in on
That case is fixed on, my lord, 38/2023.
308/2023. Requisite extra copies of the writ petition which served as an additional senior government advocate and to the Leonard standing counsel for APSC in course of the day. Next, for the appointment to the post of, what is the post?
My lord, assistant engineer within bracket civil under the water resource department.
Assistant Engineer Civil, the Water Resource Department shall be subject to outcome of the writ petition.
My lord, you can take, my lord, with that writ petition.
Okay, list with so and so.
WPC number 4342 of 2023. I'm grateful.
Item number 2.
In this case, my lord, petitioner, my lord, the promotion was.
I'm issuing a notice.
Yes, yes, ma'am.
I'm issuing a notice. But Mr. S. Das, counsel for the petitioner, and Mr. S. P. Sharma, the standing counsel for the respondents. You should notice a motion returnable in 4 weeks, requisite extra copies of the writ petition. So, okay, because his seniority, you will always get it when the writ petition allowed. So Gupta, I'll be issuing a notice.
So
Yes,
in
Ma'am.
person to the order, my lord, that appellate order has been passed, but it has not been annexed nor it has been challenged in this writ petition.
Next. What is? Page number.
It's not challenged.
It's not challenged, my lord. Kindly come to the prayer, my lord,
46.
in page
46.
marking in also.
46.
Of the prayer, कौन से page में है?
Mr.
Page
Gupta
20,
is
my lord.
right. You better amend your petition.
Page 20, my lord.
I have
It
seen
has
that.
not been challenged.
You have to amend your petition. Please do it. Explain to Mr. Gupta.
Challenge नहीं किया है. Okay. Prayer में.
On the both sides, sorry, Mr. G.K. Gupta, counsel for the petitioner, seeks permission to amend the prayer in the writ petition. The same shall be done in the presence of Registrar Judicial, Mr. B.K. Singh, counsel for the counsel for the FCI is present. You have to amend it. That is not sufficient. You see, your prayer is to set aside the order of February as affirmed by the appellate tribunal, by the appellate authority.
Let him file the amendment petition, my lord, that will be better.
No, you can do it because this is a motion. You will not be prejudiced.
In the prayer, we have given about this fresh order. In the prayer, we have moved about the fresh order of the
Please read the prayer.
that a writ of mandamus or any other appropriate writ be issued quashing the impugn the disciplinary action by number this thing dated 28/2/20 passed against the petitioner in connection with the charge of this and ratified by the appellate authority by this letter number J.
So you see, order of the authority is affirmed by the appellate authority. Your prayer should have been the appellate authority's order affirming the disciplinary authority. So your prayer is wrong. You make corrections. If you don't want, I am not insisting, but ultimately your petition will not survive. Your prayer should have been reversed. Appellate order has to be challenged, affirming the disciplinary authority. That you have not done. Your prayer is reversed. Please do it in the presence of Registrar Judicial and then correct his copy also, and it will come in motion again. Thereafter, list the matter in the motion column.
Or
Addition notice.
Lordship, it is a small matter, Lordship. 2002, the court, this honorable court passed the order. The DLC recommend on 2015, Lordship. The petitioner is quite mum during this period, Lordship. Today is 2023, Lordship.
Where is that? But you see this, there is a High Court order,
Yes, Lordship, it is on 2002, Lordship.
2002.
Yes, 23/5/2002.
Oh, here in your synopsis, you have written 22. That is why I did not catch it. In your synopsis, 2002 order, you are writing as 2022.
The writ petition number is okay, my lord.
No, no,
No, no, maybe, but it is 22.
Sorry, my lord, 21, 20,
page 26, Lordship.
2002.
When I'm spending my private,
2002, my.
Mr. Babu, when I'm spending my private time to read this brief, I don't read it so thoroughly,
Sorry, my.
correct? But then your writ petition has to be dismissed. He's
Yes,
right.
Lordship.
No, lord,
No,
this
delay
is their fault, my lord. I have
No, no, you see, we are bound by the judgment of this court in what you call in this Achut Shankar Das, where it has been laid down.
No, my lord, I am already recommended by the DLC.
On 2015, Lordship, on 2015.
Kindly, I
No,
may.
no, no, on
kindly, I may be
2000,
allowed to-
just in your synopsis, you.
They are delaying, my lord, they are depriving, and my lord, their fault, my lord.
2015,
Here
even if
it
it
is
is
case, my lord.
Now it is
2015.
2023, Lordship.
My lord, what happened, my lord?
No, no.
My lord, they are, my lord, doing mistake, my lord, and behold, your lordship, they are paying, my lord, to get benefit from their mistake, my lord.
No, no, no.
This is, my lord, lordship, in this regard, I have
Should have come
also,
at that point of time.
lordship, kindly, have a look, I have, my lord, submitted two judgment in this regard, my lord.
Where is that?
Lots
Delaying
of that
the- delay-
judgments are there.
Don't
Delaying,
disturb him.
lordship, page one, my lord,
You see, it's so disturbing when you disturb the other side counsel.
Lordship.
Correct.
careful.
Unless you have a city bus to catch, which is running on time. That I have to catch 10:32 city bus.
Yes, Lordship.
My lord, page, my lord, one judgment, my lord, I am directly showing. the
In
relevant
metropolitan
portion.
cities, you know, in Calcutta, Bombay, you have this very specific timing of city bus. If you have to catch a 2022 bus, you'll have to be at 2022. Correct.
My lord, page, my lord, 51, annexure 13, my lord. This is writ petition of 2011, my lord. I am.
Page.
Page, my lord, 51, annexure 3. My lord, I beg to refer, my lord, directly relevant portion, my lord, page 52, last part of the, my lord, judgment, my lord. The state respondent, page 52, my lord. The state respondent have not disputed the claim of the petitioner that he filed the application for appointment on compassionate ground immediately after the death of his father in harness on 5th April 2002. The said application was considered for the first time by the DLC in its meeting on, my lord, dated 9th October 2009. That is after more than 7 years of filing of the application for the fault of the department is not considering the case of the petitioner in time. The petitioner cannot be penalized, my lord. One judgment. Second judgment, my lord.
But you see you know, what is the difficulty here? Here the difficulty is that 2009.
My lord, my
the-
case is
No. In 2009, it was rejected by SLC.
SLC.
So this petitioner came to court within 2 years.
Well, I am not
394.
rejected, my lord, yet. I am not rejected yet, my lord. I am, my lord, favorably considered by the DLC, my lord. And DLC recommendation was forwarded, my lord, properly to the SLC, my lord. But SLC, my lord, are not taking call, my lord. This is my grievance, my lord. My lord, recommendation, my lord, is made by the DLC, never been, my lord, rejected, my lord.
No, so Prabhu, this is here is a case where your father retired in 1996.
My lord,
At this stage, I am not entertaining.
my lord, lordship, kindly have a look here, my lord. They forwarded recent, my lord. They page 44, my lord. My DLC recommendation.
96 is how many years from today?
No, my lord. They are, my lord. I am always ready, my lord. My lord,
No, I understand,
this is
but-
their fault, my lord.
I understand, but how many years?
My lord, here, my lord, with all respect, my lord. My
No,
lord,
no,
there is
I
a,
am
my
not
lord,
entertaining. You give a right of appeal.
my lord, another judgment,
96.
lordship, kindly,
I have seen that. I have seen that. This is what you call, that is in next page, 54.
Yes, my lord. My lord, here in this case, my lord, there is a legal procedure, my lord. It is to be considered by the SLC, my lord. I am praying for, my lord, mandamus to consider by the SLC, my lord. But there, my lord, their duty of the, my lord, SLC cannot be, my lord.
After 24, 25 years, we are not permitting that.
My lord, here in this case, my lord, what, my lord, actually law is what, my lord? My lord, there, my lord, SLC is, my lord, required as per, my lord, their law, my lord, to consider either way.
Says that
either way, my lord.
after 2 years, after 3 years, it's what you call, after 2 years, it did not be considered. It does not,
My lord, the SLC may reject, my lord, due to delay, my lord.
no, not from the order of the court. You can wait for the SLC to take up the matter, but not from the order of the court. After 26, 24 years, we are not permitting.
My lord, only, my lord, I am praying, my lord.
I am not inclined. After 24 years in compassionate appointment, I am not inclined.
They are, my lord, delaying the matter, my lord. Because of their delay, my lord, they cannot, my lord, take advantage, my lord.
I know somebody had tied up your hands and feet. You could not come to court. For 26 years, you were chained.
My lord, then, my lord, next week may come, my lord, I will try to satisfy your lord.
After 27 years.
Yes, good.
From the retirement of the father of the petitioner on medical grounds. The petitioner has approached the court. After 27 years. After 27 years, and therefore maintainability of the reparation is questioned by Mr. J.K. Goswami Ram, additional senior government advocate. Next, accordingly, Mr. A.M. Bodhia, land counsel for the petitioner, pays for and is granted time to address the court. List, you are also there.
Yes,
One,
1, 2, and 5.
Mr. P. Nayak, standing counsel for responding members.
1, 2, and 5.
1, 2, and 5 is also present. List on next week.
Yes.
List in the next week.
Oblige, my lord.
We are passing the same order in 203, same order. Will issue a notice, same order, page
Yes,
23.
Lord.
And it will
Mr.
take
R.
with that method.
R Security Council for the petitioner. Order at page 203, same order. I'm not tagging it right now. You take steps on the private respondents. Without that, I'm not tagging any matter. Here, this is Deborah and stand counsel for
1, 3, and 4.
for Health Department accepts notice on behalf of 1, 3, and 4.
4, Lord.
And Mr. P Nayak, standing counsel for
Finance.
Finance Department, appearing for respondent number 2. Who's by 5?
Society for Medical Education, Lord.
My lord, this is represented by the principal Tesco Medical College himself. Is the membership.
That should go by registered post, Lord. That
By
should go
registered
by- I
post.
can upload.
This is the registered society.
Yes, Lord.
Okay.
The
The
government-
relationship respects within. No, but if he's the member secretary come principal,
Yes, ma'am.
then I think you'll have to accept notice.
No, Lordship.
It's a government society, my lord. Not government, it's a registered society.
Huh?
Hospital
Registered
society. It's a registered.
Oh, hospital managed society.
Yes. sir.
No, this is Society for Medical Education.
Yes. ma'am. Local MLA is the chairman and principal is a member secretary.
Huh?
The local MLA of the constituency my lord, is the chairman.
Oh, no, if it is MLA, then it's not the government. You will have to take steps then.
All right, I'll take it.
Steps within 2 days for service of notice on respondent number 5 to 15 by registered post with AD. Requisite extra copies of the applications of the State and Departmental Council, Learned Department Council in course of the day. So push it 4 weeks, list after 4 weeks.
My lord, pursuant to the appointment, my lord, many has not joined, my lord, because there are certain discrepancies in their credentials. My lord. May I pray, my lord, 2 posts may be kept vacant, my lord. Otherwise, my lord, the issue is otherwise serious. my lord.
You just say, issue notice, including notice on the prayer for interim leave. Next, the prayer for interim leave shall be considered on the next date of listing. You take instructions by them, because otherwise we'll take up this issue.
To the
The,
next returnable date, Lord.
and a fixed date, give a fixed date after 4 weeks.
15/9.
All right.
6.
Take a specific instructions on that allegation that the during the rules they were appointed. Specific instruction on
Yes.
that.
Apply, sir.
Six.
May I please, your lordship?
My lord.
Okay, I'm issuing a notice.
Lordship. Kindly peruse page number 119, Lordship.
119.
Yes, Lordship. The clause 7 of the notification, Lordship.
7.
Yes, Lordship. Engagement shall be strictly in order of seniority come merit, beginning from the minimum of 10 years continuous service as Anganwadi helper in respect of seniority and passed in class 9 examination in respect of her academic qualification. Then Lordship, page 6, para 3, where the petitioner has admitted that she is only class 8 pass, Lordship.
Where is that?
Page 6, paragraph 3 of the petition, Lordship.
Yes.
Earlier you were referring to which page, Mrs. Bhattacharya?
Page 6, Lordship.
No, the earlier page you showed me.
Earlier page, Lordship, this is 119, Lordship.
119, yes.
Yes, Lordship, in clause 7.
Six.
Regarding promotion, Lordship. Engagement shall be made strictly in order of seniority come merit, beginning from the minimum of 10 years continuous services Anganwadi
I
helper.
think there's some page mistake here.
Oh,
119, we are not getting it here.
113, Lordship.
13.
13, yes, Lordship. It is written so. 113, Lordship, guidelines.
113, yes.
Yes, Lordship. In paragraph 7, Lordship.
That is. correct,
Then
my lord.
Lordship kindly peruse the order passed by the Director Social Welfare, Lordship. This is page 146, Lordship. And the relevant page is 147.
No, just a minute, then I'll hear Mr. Ahmed first.
My lord, we have, my lord, there is a specific allegations against the private respondent, my lord, who was.
No,
appointed,
if
my
you are yourself not
lord.
qualified,
My lord, she was irregular, my lord, from her appointment as a helper, my lord. There is a, my lord, many various complaint is there, my lord. We have annexed, my lord. And my lord, she was, my lord, in another center, my lord. And interview was held, my lord. Thereafter, she was appointed in my center. Where in my lord, in my center, from 2012 to 2022, this petitioner was the IC worker. IC worker.
no, you see, Mr. Ahmed, the
my
point
lord,
raised
at
is,
this
point
stage, my lord,
raised is that
notice may go,
since you are not qualified to hold the post, at your instance, why should we question the appointment of the
Lord,
private respondent number 6?
We made, my lord, private respondent, my lord, and my lord CDPO. She is also, my lord, responded, my lord, 5. My lord, let them
Mr.
come, my
Ahmed,
lord.
You know,
Notice
I
may
am,
go, my
I
lord.
am from the age when we had this record player. If there was any scratch in the record player, it would stop there. It will, the turntable will go round and round, but the pin will be there only. So my question to you was that if you yourself don't have the necessary qualification, why at your instance we shall question the appointment of respondent number 6?
That, my lord, she was appointed in the year 2009, my lord. At that time, she was class 9 pass as a helper. She was appointed, my lord. And that, my lord, advertisement was, my lord.
You are not
published.
9 pass, your own
My lord,
statement is
my lord,
there.
Notice may go, at least, my lord,
It
notice
is-
may go.
it is
at
your-
this stage,
it
my
is,
lord.
Mr.
Let them
Ahmed.
come, my lord.
Mr. Ahmed, it
The
is your
private
statement
respondent.
in paragraph 6 that you are not 9 pass. We'll be
Well,
dismissing the writ petition. No,
My lord, she was, when she was appointed as helper, my lord, she was 8 pass. That is admitted fact, my lord. Thereafter, my lord, where my lord 9 pass qualification, where did she, my lord, obtain? How, my lord?
where is the guidelines at that point of time when you were appointed? Where is that guideline?
That is not annexed, my lord.
So you see, number one, when there is a change of criteria, you did not challenge
Yes,
it.
my lord, page 25, my lord.
When there was a change of criteria, you did not
Yes.
challenge it.
Page 25, my lord.
Such qualified
She
candidate.
was appointed as
will
helper, my
be-
lord, earlier. Female helper, my lord, she has 12 years experience as a worker, my lord. She was IC worker.
But Mr. Ahmed,
She ran the,
when you don't challenge the the criteria,
and my lord, my representation, my lord, that was not considered.
you are not, in this
That was
case, you are not
rejected.
challenge the criteria.
That is why the petitioner come.
Lordship's
Lord,
representation rejected, not considered,
I-
lordship.
I can-
It
I
can be
do not-
considered
Mr.
rejected, lordship.
Mr. Anand, if you don't want to understand, I can't make you understand. I can merely make a statement, but it is for you to understand. This change in criteria, you have not challenged it. Without the challenge, can your repetition be maintainable? You said that earlier it was class 8, you could have joined. Well, you have shown it. But now it is 9 pass. So don't you have to challenge the criteria?
There are various complaints against her. She was irregular in her capacity, official capacity. That is why the petitioner come. Numbers of complaints.
And
I
I
have
have to
annexed-
dismiss it.
That was
If
one
you
ground,
don't,
my lord.
if you don't want to understand, we'll have to dismiss it.
My lord, my only submission is, my lord, at this stage, my lord, notice me.
I'm asking you a
Let
legal
them
question.
come, my lord,
Mr.
private respondent.
Ahmed, I'm asking you a legal question. I've got nothing to do with sympathy. I'm asking you a legal question. Is your reputation maintainable otherwise?
That notification, my lord, 2009 notification. That were described, my lord, by the present notification.
I
This
can't
was
make
my
you
lord-
understand. I can't make you understand. You don't even want to pray for an amendment of the reputation. What can I do? If you're not challenging the criteria, we'll have to dismiss with liberty to approach the court again. Well, Mr. S. Ahmed, counsel for the petitioner.
I challenge the
Counsel for the petitioner and Mrs. M. Bhattacharjee, additional senior government advocate appearing for respondent numbers 1 to 5. Next one. The learned counsel for the petitioner has submitted that when the petitioner had joined service, she was duly qualified in terms of notification dated 2009, as she had passed class 8. to stop. Accordingly, he submits that the change in criteria by notification dated 4/3/2013 would be put to challenge, where the requirement is that only that those who have passed class 9 shall be considered for promotion to the post of Anganwadi worker. Stop. Accordingly, he prays for leave to withdraw this petition and to approach the court again. Prayer is allowed. This petition stands closed on withdrawal with liberty to challenge the notification dated 4/3/2013. I will challenge it and then come again.
Deeply obliged.
oblige.
It's a compassionate appointment matter, my lord.
Let us wait for some time. If the petitioner comes, otherwise we'll adjourn it.
My lord.
Item number 9,
I think 8 adjournments. We'll issue a notice. Benefit of Upendas has to be given. But Mr. J.U. N.M. Raskar, counsel for the petitioner, and Mr. S. Datar and standing counsel for PNRD, and Mr. P. Nayak and standing counsel for the finance department. The PNRD will be 1, 3, 4, and 5. Finance department number 2. The petitioner claims benefit of the ratio laid down in the case of Upen Das versus State of Assam and others. State of Assam versus Upen Das. No? Next one, issue notice returnable in 4 weeks. Requisite extra copies of the reparation is out of the London State and Department Council in course of the day. Next one, the pendency of the reparation shall not be a bar for the respondent authorities to consider the claim of the petitioner
All right.
and take suitable action.
All right.
Then.
Yeah, there is a claim for pension benefit and others. Relief
I'll issue a
matter.
notice.
Now notice will
I'll issue a notice.
Lordship, here in this case, Lordship, the CDPO Mandya is not sent the proposal of the petitioner, Lordship. Therefore, the copy is, notice may issue.
Yes, notice. In Kargan law. How? Kargan law.
Notice to the CDPO project.
Company office. Corporate division.
One and two.
Heard. Mr. R.P. Sharma, Senior Counsel, assisted by Mr. Teli, Counsel for the petitioner, and Mr. J.K. Goswami, and
One and two, Lordship.
standing counsel for the additional senior government advocate appearing for respondent number 1 and 2. Treasury officer will be
Treasury officer, P. Nayak.
Mr. P. Nayak, standing counsel for
Accountant.
Finance Department, representing respondent number 3. And
B. Chakraborty.
Ms. V. Chakravarti for standing counsel for respondent number 3. Issue notice, return within 4 weeks. Requisite extract copy of the requisition will served on the land. State and departmental council in course of the day. Next, madam. The tendency of the writ petition cannot be a bar. For the where do you say that this CDP has not issued the
Lordship, when, Lordship, I got the instruction from the director office, Lordship. It
Okay.
appears that there is a letter sent by the director office to the CDP office that to submit the proposal of the petitioners. But then,
tendency of the repression is not be a bar for the CDPO. CDPO which place?
Mandial CDS project, Lordship, Borpeta,
Mandia,
MANDIA,
Mandia. ICDS project,
Lordship.
district Borpeta to. No, not Mandia. In paragraph page 5, he is saying Guijan.
Question, but so far in my letter, Lordship,
For the concerned CDPO,
was concerned CDP.
concerned CDPO to send the
Subsequently.
pension proposal of the petitioner to the competent authorities and for the competent authorities to take appropriate decision on the on releasing the family pension to the petitioner on account of death of his wife. Next, list after 4 weeks. You will give a certified copy to the CDPO. Will permit you to do that. It will be faster. The petitioner is at liberty to produce a certified copy of the order before the concerned CDPO to expedite the matter.
11.
Yes,
Was a contractual employee.
but this order of termination is not what you call, it's not stigmatic. It is in consonance with your contract.
After for 1 month, appointed for 1 month.
No, you see, you're a contractual employee.
Yes.
You will be entitled to 1 month notice in lieu of salary.
Yes.
Or 1 month salary in lieu of notice.
Yes.
Correct. So when your contractual term says that you can be removed on the
Clause 11.
clause 11
Clause 9.
of
Clause
this, if your conduct becomes questionable, then you will not be entitled to reinstatement at any cost. Then your reputation would not be maintainable.
Terminated without any notice, any.
No, it's not required. You were arrested by the police. So therefore, your conduct and as per this termination clause, it was a perfect ground to release you.
As per clause 9, I am terminated.
9.
9.
That is. Clause
9 is
9
non-disclosure
wrongly-
information. Non-disclosure information is doesn't help you.
In view of the above, and in percent of clause 9 of the item.
You see this. See section 14 clause D. Contract which is not specifically enforceable.
Fourteen D.
14D, so it is determinable in nature. So even otherwise, your service could have been terminated with 1 month notice. So it's a contract which is not specifically enforceable.
As per article 311.
311 would not apply to you. Because you see, there is a contract. This contract cannot be overridden.
Yes.
This contract says that if your conduct becomes questionable, then your service can be terminated.
Yes.
And they have utilized that because you were arrested by the police.
Others also not framed.
It's not required.
Yes.
Unless you can show me that there's a requirement to give you a charge sheet on a terminable clause. Otherwise, I find that this is a case for dismissing your reputation. But Mr. L. Gogoi, counsel for the petitioner, and Mr. S. Datta, standing counsel for the
1, 2, 3,
Panchayat
4,
and
and 6.
Rural Development Department, appearing for respondent number 1, 2,
1, 2, 3, 4, and 6.
1, 2, 3, 4, and 6, and Mr. H. Chakravarti, and as government advocate appearing for respondent number 5. Next paragraph. The order, impugn order of termination dated 28/3/2023, issued by the respondent number 2 is filled in this petition filed under Article 26 of the Constitution of India. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner was appointed as a
Computer.
contractual computer assistant, computer assistant on contractual basis. Right, order dated 27/2/2009. So the petitioner joined service on contractual basis on 2/3/2009, and the at the LOTAK, Gaon Panchayat, District Dhemaji. From time to time, the contractual appointment of the petitioner was extended. And in the year 2018, the petitioner was transferred from Lotak Gaon Panchayat to Kachutali, KACHUTALI Gaon Panchayat in the district of Dhanaji. And not last, he was transferred to there, and thereafter he was again transferred to Naharbari, NAHARBARI Gaon Panchayat in the district of Dhanaji. Full stop. Next one. On 12/3/2023, the controller of examinations on a Board of Secondary Education Assam had lodged an FIR with the CID police station to the effect that, as per news telecast in a section of media, handwritten model question paper of the HSLC examination of general science, which was to be held on 13/3/2023, was available in the hand of certain candidates. Accordingly, CID PS case number 3 of 2023 was registered under section capital 120B, 420, 427 and 409 IPC, read with section 66 capital B of the Information Technology Act 2000. Full stop. Thereafter, the petitioner was arrested in connection with the said case on 17/3/2023 by suspecting his involvement. Full stop. The petitioner was released on bail by order dated by order of this court dated 12/5/2023 in BA 1606 of 2023. Mr. Flower. The grievance of the petitioner is that his service was terminated by an order dated 28/3/2023 without issuing any so-called notice to the petitioner and without complying with the principles of natural justice, as the petitioner was not given an opportunity of being heard. Stop. Next, the learned counsel for the petitioner has submitted that the principles relating to inquiry before termination as envisaged under Article 311 within bracket 2 of the Constitution of India was not followed. Stop. It is submitted that the order of termination was stigmatic and therefore principle of the natural justice was required to be followed. Next paragraph. Opposing the prayer made in this petition, it is submitted by the Learned Standing Counsel for PNRD that the petitioner was terminated by invoking clause 11 of the terms of contractual engagement as computer assistant. The said clause is expected below, page 17/18. Hence, it is submitted that as the conduct of the petitioner was found to be involved in an act which has become embarrassing for the respondent authorities. It was within the power of the respondents to respondent number 2 to terminate the service of the petitioner. Next paragraph. The court finds that in the terms of contractual engagement of the petitioner as computer assistant, clause 2 of the said terms provide that the contract, the contract may also be terminated without assigning any reason before the contract period by either party, subject to giving 1 month's apostrophe s 1 month's advance notice to the other party. So moreover, as indicated in clause 11 of the agreement, in view of the arrest of the petitioner in connection with the PID case number 3 of 2023, it cannot be said that the conduct of the petitioner would not have been found embarrassing by the to be embarrassing by the responding authorities. Next paragraph. As the contract service of the petitioner is terminable by giving 1 month's notice. The court finds that the petitioner is entitled to the relief of his service being restored. In view of the provision of section 14 within bracket D of the Specific Relief Act, which provides, inter alia, that a contract which in its nature, contract which is in its nature determinable are contracts which are not specifically enforceable. Mr. Datta, can you ask the authorities, this commissioner, to issue a termination order simply citer? Because on the basis of the order of the court, you give him a termination order simply citer so that he can get service. Otherwise, from this order, he will not be entitled to any service.
Although it's not stigmatic, my lord.
No, it is stigmatic. This contains stigma that he was arrested and therefore terminated. So we provide from the in view of the order of the court, you give a terminated simply citer. Next paragraph. Although the court is disinclined to interfere with the order of termination, impugned this dated 29 sorry, give a number, page 29, huh? Number so and so, dated so and so. Issued by the Commissioner, PNRD Department. Comma, okay, this part let me think over. Because in the order of your bail, this court had recorded that the case diary indicates that you are one of the prime accused involved in the question paper leakage.
No, no, Lordship, I have so WhatsApp received handwritten 20 question.
No,
model
no,
question.
maybe that, but this court while granting bail
Yes.
arrived at a prima facie conclusion that you are one of the main accused.
No,
So
I'm not-
if under that circumstances, if I direct that a simplified order of termination be given, then you may get a government employment anywhere.
I am not a
No.
main accused.
I don't know, let me think over.
News also, because there 40% is the main accused.
No, I don't know, but it is your order which you have annexed at
I'm
page
just
27, I'm
received
reading.
20 model question through WhatsApp.
No, no, whatever
is
we,
the-
but let me think over. Let me think over. This is something which may give any other right. Let me think over this part.
Lordship is disposing of.
Yes, even disposal, only that part, whether I
My
should
lord.
give it a direction of simpliciter or not.
My lord.
Let me call to the records and find it out.
Okay.
Highly obliged.
You have to issue a notice here,
Yes, notice.
and appointment will be subject to outcome of the writ petition.
Yes, that's
Heard Mr. Y.S. Manan, counsel for the petitioner. Who is appearing for the state? You will be there. Mrs. Miss M. Bhattacharjee, 11. Additional senior government advocate appearing for respondent number
1 to 4 and 7, Lordship.
1 to 4 and 7. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition is served on the additional senior government advocate in course of the day. Next, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 5,
5, 6
6 and 8 by registered post with AD. Next, para. The appointment of private respondent as in what capacity they are appointed?
They are appointed as Anganwadi worker.
Anganwadi worker shall be subject to outcome of the writ petition.
Mat. 7.
Wait, is my, pardon me, I was late, just.
It's okay.
I could not.
But why should we entertain your application now? Your predecessor died in 2010.
Yes.
Your reputation would not be maintainable.
Before the Lordship Lord, with only one prayer, his sister-in-law, she benevolently came forward and gave an application to the authorities seeking to save the family. Her brother-in-law should be appointed. She is having a job of her own, so she'll not take her husband's job. And maybe compensated with her brother-in-law's job, because she is well placed. That is.
I'm not
my-
getting you.
My lord, the petitioner's sister-in-law, it should have been appointed as in the completion appointment. But as she's appointed as a teacher, she is having her own income. So she is benevolently came forward and said that her brother's post will be taken up by her brother-in-law. That is my prayer for Lordship. And next year, they represent NXT two, my lord, page 15,
Page,
page 15. 15, NXT two, that is a representation by the petitioner's sister-in-law. Prayer for an appointment for the post of a clerk on a compassionate ground. Most humbly and respectfully, I have the honor to state that that is a representation by her.
no, your reputation will not be maintainable.
The DLC has, I'm just before your lordship, just with the prayer that he may be appointed.
No,
not
no, you see,
appointed, But a direction that is if
Ms.
possible.
Sinha, your reputation is misconceived. You say that your husband died
Not
in
my-
2010, correct? You
uh,
give a letter to the authorities that instead of you, they will appoint the brother of your husband, correct?
yes.
Now,
But-
after 2010, now we are in 2023. Now you have come. What is your right when you have relinquished that post? Your brother-in-law did not come to court. Who wants the service? You want to catch his finger and take him to the appointment, to make an appointment?
My lord. She said that she's appointed, already appointed.
No,
as a
I don't know.
charity department.
So far as I remember, since my childhood, I never had to. My parents had got me admitted to a school, and thereafter he never got my finger to take me anywhere.
My lord, he died.
You
in
are filing a
2010.
petition for whom?
The petitioner.
What is your right? How you are aggrieved? You see, a repetition is maintainable only when you claim some relief for yourself. What is the relief you are claiming for yourself?
His brother died, somebody was surviving, nobody,
no,
he
no.
was
No,
surviving.
no. If somebody has died, somebody else will get the post. You can't agitate the cause of another. Misconceived petition.
It's just a matter, it's a prayer before Lordship, before the authority.
I have considered your prayer. For the last 5 minutes, I am doing that only. I have considered your prayer, but I am rejecting it. It can't be done. You can't agitate for your brother. This is a proof that your brother is otherwise he is not a fit person to join.
Yes, he has shown my ration
No,
card
no.
and all, his mother is just having hand to mouth existence, my lord.
No.
Seeing all this, his sister-in-law has made
No,
some
no, but
prayer.
your
for the
reputation will
authority.
not be maintainable. At your instance, it can't be maintainable.
Before the authorities
I-
as well.
this D. Sinha, counsel for the petitioner, and Miss
Kotoki.
M. Kotoki, and government advocate appearing for respondent number.
Council, my lord, Animal Husbandry and Veterinary Department.
Standing counsel for Animal Husbandry and Veterinary Department, appearing for respondent number 2 and 3.
2 and 3, my lord.
From the nomenclature of respondent number 1. It is not known as to which authority is being referred to. Next para. By filing this declaration under Article 226 of the Constitution of India, now the case projected by the petitioner is that her husband who was at that point of time working as VFA. What is VFA?
Veterinary Field
Field assistant.
Veterinary Field Assistant, my lord.
Okay, veterinary field assistant expired on 15/7/2010. And on 29/2010, the petitioner purportedly submitted a representation before the district veterinary officer, Silchar, within bracket respondent number 3, that that her brother-in-law, namely Prasenjit, Prasenjit Sinha, be appointed on compassionate ground. Full stop. Accordingly, the petitioner now by filing this repetition and Article 226 of the Constitution of India has prayed for a direction upon the respondent authorities to appoint the petitioner in the veterinary department or any other department in grade 4 post on compassionate ground. Next paragraph. Compassionate ground circular. But it appears that at the time when the husband of the petitioner had died, OM dated 2/3/2009 was in force. Going to 2009 on compassionate ground, an appointment for appointment on compassionate ground was in force. Mr. As per clause 10 of para so of the judgment of this court in the case of Achyut Ranjan Das versus State of Assam and others. This court has categorically held that applications which were pending for clause 9 of para 7 citation is 2006 4 GLT 674. It has been that if the applications of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such applications, all such applications will require no further consideration and must be understood to have spent their force. Next paragraph. At that point of time, the reservation was on the basis of 5% of vacancies arising in a year. So the petitioner has not been able to show that the vacancies of the year 2010 are still available for filled up in the quota of compassionate appointment. That's according to the moreover, it is noted that it is the case of the petitioner, admitted case of the petitioner, that on 29/2010, she had submitted a representation before the respondent number 3, indicating that he was relinquishing her claim for appointment to compassionate on compassionate ground in favor of her brother-in-law, Prasenjit Sinha. Therefore, after a lapse of 13 years, to turn back and make a prayer for file a writ petition with a prayer for directing the respondents to appoint her as her in the veterinary department on compassionate ground is not tenable, and the same not tenable, more so as the petitioner has made a statement in the synopsis of this writ petition that the petitioner is holding a job. No case is made out by the petitioner for considering candidature for compassionate appointment. Just according to this writ petition,
My lord, the
stands dismissed
petitioner is
at the
not-
motion stage without difference of
Sorry,
notice from
my
the
lord.
respondents.
Sir, the petitioner is not holding the job. Petitioner is holding a different job, not in the veterinary department.
No, different job. I'm not saying the veterinary
Yes,
department.
yes,
There is a ground to dismiss it. I have not said that you are joined veterinary department.
Chief job. Chief job, obliged.
Your lordship, that I may pray for 2 days' time, because that on 22/9/2022.
2018 matter, why you need some time?
Your lordship, I have been directed to produce the management witness deposition on 22/9/2022.
No, if it is not there, we will proceed with that. You see, this is a 2018 matter.
Yes, your lordship, only 2 days, your lordship.
You look at this order of 19/6, which says that with the consent of other side, counsel for the respondent bank seeks adjournment of admission hearing of this case with a request to post this case again after summer vacation. So summer vacation is gone.
Yes, your lordship. Only 2 days, your lordship.
If you don't bring it within 2 days, then we impose a cost of 15,000 on you to be paid to the petitioner.
No, your lordship, actually,
No, it's okay. I'm granting you 2 days time as prayed for. But if after 2 days you don't produce it, then 15,000 cost to the petitioner.
lordship,
No, you have to pay because today you are asking for 2 days. I'm granting you 2 days.
the file was given to me, but
It's okay. You're asking for 2 days. I'm granting you 2 days. But then can you prevent me from passing an order not to impose cost if 2 days, within 2 days you don't get produce that order? Then you possibly can't. So T. Deori, counsel for the petitioner is present. Mr. M. Sharma, Leonard, counsel for the respondent bank. Case for is granted 2 days time to produce inquiry records containing the deposition before this court. Next, the respondents are put to notice that if the failure to produce the records within the time allowed, comma, the respondent should be ready to pay a cost of rupees 15,000 towards adjournment of the matter today. Next para, list on, give it Monday, 21/8/2023.
Your lordship may not be given on 21, may be given on Friday, your lordship, I have no issue.
Friday, you will get a walkover because on that day there is a holiday. I won't be coming. Mr.
Then
Deori
Thursday,
will
your
not be
lordship.
coming. Thursday. Okay, Thursday then. 17.
Give your lordship.
14. Matter here, dismissal from service, matter after inquiry, department inquiry, matter, the record,
You were lying unconscious in a, what you call, in an inebriated stage.
yes. Not record is, original record is not yet received, my lord. Record may be called, my lord, because I want to examine the evidence of witnesses. What they-
Original record
they
is
said.
necessary, my lord, and
In the case of.
It's a 2019 matter,
yes, yes, my lord. Earlier record actually not called.
not called.
Not called, yes.
Okay.
Still sort of by. September.
Mr. R.P. Sharma, Learned Senior Counsel for the Learned Senior Counsel assisted by Mr. P. N. Sharma, Counsel for Petitioner. Please that the disciplinary records be called for. The Mr. K.K. Parasharan at CEC also prays for some time to enable him to produce the records. Next, accordingly, list this matter after 4 weeks so as to enable the learned CEC to produce the records. Next paragraph. The learned CEC is at liberty to send a downloaded copy of this order to the competent authorities of the CRPF so as to produce the records on the next date.
Madam, I think on seventh of.
It's in 4 weeks.
Madam,
Make a mention
Madam.
when the records comes.
It will come for hearing, my lord.
No.
No, I'll be very happy, but you see what you have done is you made a prayer before the earlier bench of this court and you got an order that endeavor we made to dispose of the matter at the admission stage.
No, your lordship will do it. Your lordship is a liberty now to do it. The whole matter. This was all.
No, because otherwise it has to be heard.
Yes, it is.
You make a prayer on that day. I'm not
Madam.
making it, we'll fix it at the last hours of the day and we'll take it up of hearing. Not at this stage, but we'll take it on there because I don't want to disturb the order of
Right.
the earlier bench.
Problem.
15.
Yes, you filed an affidavit. What is the ground of denying third modified
he is
actual progression
lacking in ACR lordship.
lacking in ACR?
Yes.
Have you been communicated that
Our stand is that it is not an adverse entry. That is why communication.
that
Yes.
has to be communicated after
Lordship, Sukhdev and Devdutt.
Devdutt? I passed an order a few days back.
Yes.
Where is that order?
I have the case number, madam.
You have the case number.
4418 2020.
Double,
4418 2022.
just write it down.
Order dated 2nd of August.
Wait 23. We'll fix it on day after tomorrow. Let me get that order. Then I'll see what changes are required. If you can get the order, you just make the necessary corrections there. Same thing, MSCP will be considered.
She has to be communicated, Lord.
It has to be communicated. So day after tomorrow, they list this matter. 16/8/2023.
Apply.
In the meantime, you get that order, you make necessary corrections on it.
Right.
16,
Just also right, as per for the petitioner, is B Sharma, CGC for the respondents present. Yes,
May I please your lordship?
you've got instructions?
So Lordship, in terms of your Lordship, last order, Lordship, I received one instruction on 7th, Lordship, 7th this month. Lordship, there they have directed the necessary instruction from the health department, Lordship. Today I'm praying for some time, Lordship. The basic instruction required whether the case of the petitioner was placed before the DLC or not.
Yes.
That instruction is this.
Okay, you can get it by 2 weeks.
Lordship.
Let him find out. Your name? Mr. D. Barwa, counsel for the petitioner. Mr. E. Nayak, learned study post for BTC. Submitted that he has received written instructions dated 7/8/2023. By which the Joint Director of Health Services, Udalguri, is asked to submit relevant documents. It is submitted that the BDC authorities want to ascertain as to whether the claim of the petitioner for compassionate appointment has been placed before the DLC. Next one. List after 2 weeks, so as to enable the learned standing for BTC to produce appropriate instructions. For the government, you will be there.
One is.
Embatasaji, government advocate, additional senior government advocate appearing for respond number 1 and 5 shall also obtain instructions as to whether the claim of the petitioner for compassionate appointment has been placed before the DLC.
SLC Lordship.
SLC.
Yes.
Not a DLC, no, but SLC.
In my case, it will be DLC Lordship.
In your
What has-
case, it will be,
DLC.
No,
Because I'm
unless-
appearing for BTC Lordship.
no, unless the DLC approves it, it won't go
It
to
will
the
not be
SLC,
placed, Yes, that is there.
but you are asking her to produce the records of SLC.
No, if your Lordship, if she is required to obtain any instruction Lordship, she will obtain it from the SLC only. But so far as DLC is concerned, it will be my responsibility. So at this stage, Lordship, she is not.
She is not required. Okay. Not again. Okay. The learned standing counsel for the BDC may send a downloaded copy of the order to the respondent authorities to ensure receipt of appropriate instructions on the next date. List after 2 weeks.
Can date be fixed, your lordship? Date be fixed, your lordship?
Okay, after 2 weeks, give a date. I'm returning you your
Lordship.
letter. Give a date after 2 weeks.
19,
Lordship.
17.
May I please your lordship? The respondent was also supposed to file the affidavit. It was not been filed. Lordship.
That is Forest Department. Lordship.
For a department. Gogoi was there, lordship. He had informed me that their affidavit is ready and the signature is ready. Lordship, it takes up to 2 weeks. Lordship.
Let him come
Yes, lordship.
after some time.
Lot.
Let him come. Okay.
Maybe Lordship.
Lord, this
Regarding the constitutional deferment, my lord, the last adjustment instruction was called for the petitioner initially.
Yes, you got instructions.
Lordship, I have taking some time, Lordship.
Huh?
Seeking some time, Lordship. Time is-
But this 2020 matter, you see,
Adjustment and
2018 is being pending.
Yes, ma'am.
The recommendation was made in 2013.
13, and SLC was rejected in 18,
18, Lordship.
5 years back.
How much time?
Lordship, 2 weeks, Lordship.
But you are. You see, instead of making an inquiry into why there was a delay, we'll still issue a direction to the SLC to consider his case. You see, that inquiry won't take us anywhere. Now let us say that the authorities give a reply, but still his case has been rejected by the SLC.
Lordship.
And this non-presentation was is not in terms of Achyut Ranjan Das. Instead of making that inquiry, that will only cause delay. And just hear the order, huh? Mr. H. Ali, counsel for the petitioner. Next paragraph, Mr. J.K. Goswami, additional senior government advocate, has referred to order dated 21/7/2023 and placed for 2 weeks further time to obtain instructions as to the cause of delay in placing the matter before the SLC after 5 years. Next paragraph. The respondents are put to notice that in the event the respondent authorities are unable to produce any authentic record disclosing the reasons for the DLC recommendation not being placed before SLC for 5 years. The state is put to notice that on the failure of the state to produce reasons documented in the official file for the delay, the court would be inclined to interfere with the minutes of the state level committee dated 28/2018, directing the state respondents to once again consider the claim of the petitioner for compassionate appointment in view of the DLC recommendation made on 28/5/2013. Next, list after 2 days, 2 weeks. So I'm putting the state to notice. You are also there. So P. Nayak, standing counsel for finance, representing respondent number. Oh, you are for PWD?
Yes, sir. Yes.
PWD, Mr. Nayak would be for 1,
1, 2, and 5, Lordship.
1, 2,
1,
and
2,
5.
4, and 5. Lordship.
1, 2, 4, and 5, and Mr. J.K. Goswami for respondent number 3.
Lordship, otherwise, Lordship, the SLC is not the party here, Lordship.
May not be used, but those things will not be deterrent. But yes, Mr. Ali, you'll have to amend it. Ultimately, even the chief secretary of the SLC will have to impede. He's right. technically he's right. It's a 2020 matter. I think you'll have to file an application for implementing.
Yes, miss.
You do it, otherwise he is right.
My date may be being definite.
I'm not fixing a date. You'll have to file an application for correction of the cost title. You'll have to amend it formally. Because neither the chief secretary is a party nor the SLC is a party.
Yes.
So this order which I am proposing to pass can't be passed. He's right. Do it.
19.
You file an application and amend it.
Your Honor, kindly pass over the case.
Okay, that's not. You have the service rules of the,
Yes, my lords, I have printed it out. I have it printed, my lords.
you have it,
My lord may have my copy.
pass it on.
This is the most up-to-date service regulations, my lords. This has the 2013 amendment as well as the 2018 amendment. Material portion is. in-
Just one. Which is the appropriate rule?
Lords at clause page 6, clause 10. Page 6, clause 10. Lords, I apologize sincerely because the pages are not numbered. My right hand is paralyzed, Lords, so I could not write it on time. Termination of service by notice. my lords.
Just one. Okay, how much time you want? How much time you want?
Whatever goes.
Whatever one the court decided.
Fix it after 2 weeks then. On the prayer made by Learned Council for the petitioner. We see both sides are represented on the council. Petitioner. Matters is adjourned to at least after 2 weeks. Returning with this,
My lord, may I have it? I have.
you.
I'll
take
file
it
it,
and
my
give
lord.
it, and then so it's easier for us.
Yes. As
Next date you present this again.
20.
honored by us. My lords, advance happy Independence Day. Advance happy Independence.
My lord, in this matter, my lord, will file the affidavit during the course of the day, my lord. My lord, affidavit is ready, my lord.
Okay. Both ways are duly represented.
My lord, on behalf of Mr. Gigo.
Yes. But what in council appearing on behalf of Standing Council for Finance and Taxation Department has provided a copy of the affidavit in opposition to the Learned Council for the petitioner and submits that the affidavit shall be filed in course of the day. Listed on Monday then?
Yes, sir.
The matter will be listed on Monday. 21-8.
21
The registrar
Alright.
shall tag this affidavit on record.
21 and 22.
Please, Your Lordship. My lord, this case relates to my lord, the petitioner were appointed ad hoc, my lord. And now, my lord, they have issued a impine order with a view to terminate them and to get some ad hoc, my lord. Ad hoc to be, cannot be replaced by another ad hoc, my lord. And last occasion, my lord, record was called for and no reasonable opportunity of hearing was given to us, my lord, before issuance of the impune termination order. Before that, lordship will see have been engaged at page 24, my lord. Page 24.
Just
That is
a moment.
our engagement order, my lord. After engagement, my lord, we have been issued our,
It's only a daily wage appointment. It's only a daily wage appointment. What is the substantive right to be there?
my lord, my right is only, my lord, ad hoc shall not be replaced by another ad hoc, my lord. That is my case only.
Okay.
And my lord, before issuance of the impine order, lordship will go through the record if they produce, my lord, whether any reasonable opportunity of hearing was provided to me or not, my lord.
No, that is,
Because, my
that
lord,
is- that is
similarly,
not-
my lord, what they
that
are,
is not required. It's not a stigmatic removal.
my lord, they
It's only a
cannot
day
do,
wage.
they cannot do choose and pick up, my lord. Some persons still are working, by which, my lord, I have filed an additional affidavit in reply, my lord. Similarly situated,
No, you
persons.
see, if I have engaged a daily wage worker,
my lord,
today I have a requirement of 5.
my lord.
So I'll keep 5 and I'll, because
That is true, my lord.
how is an assessment required to be made?
My lord,
Supposing I want, I want to clean this room.
my lord,
I engage 3 people
my lord,
and in 3 days, in 1 day's time, it is not completed. Tomorrow it has to be done again.
my lord,
So now I require 1 man.
my lord.
So do you think that I will have to spend my time making an assessment of
No, my lord, I'm not onto that, my
three labor?
At least, my lord, reasonable opportunity has to be given there. my lord.
No, no, no.
They are similarly, they are engaging, my lord, some other persons, my lord, equal footing, my lord.
No, no.
The right to equality, my lord, they started me
But
only,
daily wage worker right to equality is not there.
but they shall not, ad hoc.
No,
shall
no,
not be
then I open a Pandora's box. You see, now, for example, in Manrega, you have 100 days, what do you call assured work.
guaranteed work.
And supposing in a village, if there is a work of 100 days and there are 1,000 applicants. So they distribute the work to everyone. Then you will again ask that natural justice has to be complied with, subjective assessment is to be made.
Simply is that, my lord,
No, no, no.
the ad hoc shall not be replaced by another ad hoc, my lord. If they need another person, we should be given chance. They should not engage some other person in my place.
But
If
daily
they-
wage worker,
No, same person,
no, daily wage worker.
daily, they are engaging, my lord. I have
Okay.
filed my affidavit. Lordship
Yes.
will see from the record, my lord. They are engaged some other person. I have filed my affidavit, my lord.
Lordship, this is a case, Lordship, where the petitioners are not even able to show their engagement order, Lordship. Engagement order, appointment letter, Lordship. Even that is not here in the petition, Lordship. So,
No, as you see, for
So-
time and again, if I am engaging supposing in your house, you want to have a painting done, you engage a daily wage worker. Will you give him an appointment letter? You won't give.
for some kind of appointment, Lordship, it's a settled law is, Lordship, for whatever kind of appointment, be it temporary, be it casual, be it ad hoc, one advertisement is required, Lordship. So if that notice, in this case, Lordship, on the basis of newspaper reporting, Lordship, an inquiry was conducted, Lordship. And after conducting the inquiry with the approval of the government, these 40 persons were terminated.
Yes, wait, let Mr. Barbia complete his part, then I'll come back to you.
Lordship.
Yes, Mr. Barbia.
Lordship, my lord, I'll go, Lordship, kindly bear with me for 5 minutes, my lord.
Mhm.
Immediately after appointment, my lord, they have issued our identity card, my lord. That your lordship will see page 26 onwards,
20,
6 onwards.
yes.
They have issued us identity card. Thereafter, my lord, they have deducted our salary, my lord, deduction on the account of the provident fund, my lord, at page 31 onwards.
Page,
Page 31 and onwards.
yes.
Employment number designation, so they have given amount, these are the amount, the deduction, 2,250, they have deducted, my lord. All these things are going on, my lord. Then, my lord, page 39, they have proposed us for sending training. That page 39 be seen for a moment. Then lordship kindly turn to page 13.
Just a moment. Yes,
Then lordship kindly turn to Annexure 4, page 39. They have selected 54 numbers of MCP, that is Municipal Corporation Police, and our name appeared as page 40. Serial number 7, 11, 12, 13, 15, and 16. They intended to send for us training. That is only 18 or 18/8/21.
you can just take a break and come back.
Lost.
We liberty to file affidavit if so advised.
Lost.
No, file additional affidavit if so advised.
Apply.
It's 24/25.
24/25.
You have got instructions, you are not filing affidavit.
Lordship, in one case we have already filed, another case, Lordship, I'm just praying for a week's time, Lordship.
Okay.
Item 25, it's already filed.
Okay. There's no representation from the petitioner. Part separate officer, 24. Amber Razaji, additional senior government advocate, praised for his granted. How much time?
Lordship, a week's time is, or 10 days, Lordship.
10 days time to file affidavit in opposition in the matter. So prayer is allowed, list after 10 days.
Lordship.
In 25,
25
you
is
have already
already
filed.
filed, yes, Lordship.
Actually, 25. Petition is absent on form. Yes. Amber Razaji, additional senior government advocate is present. Next para, list after 10 days along with WBC 3285 of 2022. Okay.
Deeply authorized.
29.
The promotion matter, your lordship, from grade 4 to grade 3. On the last occasion, the respondent's forest department was supposed to bring the record.
I have the records a lot. I have the records. And there's a letter from the petitioner where she says due to some personal difficulty, she doesn't want the promotion posted lordship.
Lordship, we have already filed an FIR in this regard. Lordship, in that case, if the lordship may direct the respondents to place that letter on record by the
Yes,
affidavit.
that's fine. Yes, what are you submitting?
Lordship, I'm submitting lordship that they've brought the record. So they're saying that that she has waived off her right for promotion. Lordship, I'm asking to place the same on record by an affidavit, your lordship. Because she has already filed an FIR that she has not signed anything as such. And the private.
You're not filing an affidavit?
Lordship, we were asked to bring the records. We have the records where the letter is
No,
there.
no, but she's right. You see, it's a case, she's seeking promotion.
Yes, sir,
Yes,
lordship.
sir.
We can't decide the matter on the basis of records. You'll have to file an
Yes,
affidavit.
sir, we'll bring this
She has
letter
a-
on record, your lordship. Letter of the
She has a
petitioner.
right to know what documents you are relying on. Okay, both sides are duly represented. Mr. R.R. Goel and standing counsel for the forest
Forest
department has submitted he's ready with the records. Next para. Court deems appropriate that the respondents in the forest department should file their affidavit in opposition in the matter. How much time?
Lordship, a week, your lordship, within a week.
The learned standing counsel for the forest department pays for and granted 10 days time to file affidavit in opposition in matter. List after 10 days.
Okay.
Obliged, lordship.
Wait, please, Lordship. Lordship, in this matter pertains to the combined competitive service examination, my Lordship, regarding Andaman. Lordship, on the last occasion, notice was, what do you call, Lordship, the respondent number 7 and 8 had not appeared. This time, Lord, they have filed their Wakalatnama, my Lordship. Respondent 7 and 8, they filed their Wakalatnama, my Lord, may fix it for the respondent, may direct them to file the affidavit in opposition.
Who's appearing for 7 and 8?
Your Lordship, I'm appearing on behalf of Mr. S.K. Deori.
No, are you for 7 and 8?
Yes, Your Lordship. I am not, my name is not in the Wakalatnama. He had some medical emergency, so he had to go to GMC. I'm appearing on instruction and will file our affidavit within 3 weeks, Your Lordship.
And state is not filing an affidavit?
I'm appearing 4 and 5, Lordship. 4 and 5 has no role to play, Lordship. That's a formal party, Lordship. The APSC is the main party, Lordship. That's for 1, 2, 3, Lordship.
They will file.
Who's appearing for APSC? Is not there.
We'll direct them to file the affidavit.
No, once they don't know, they will not be filing it.
Last occasion, Your Lordship, I'll inform them.
This is- Item 30. SC, APSC. Just wait for some time. Let the APSC. will be there.
Lordship, they're here.
Yes, you are not filing affidavit?
Lordship, we have sent the affidavit for vetting, Lordship.
Okay.
It will be ready within 1 week. We'll file it.
Also the delivery represented. Mr. A. Chakravarti Ranade. Government advocate appearing for respondent number
4 and 5, Lordship.
4 and 5 submits that they are only formal parties and would not be filing an affidavit in opposition in the matter. That's why the council for respondent numbers 1, 2, and 3, as well as 7 and 8. Prefer and granted 3 weeks time to file affidavit in opposition in the matter. List after 3 weeks.
EPM.
Obliged, Lordship.
Party 1.
May it please, Your Lordship.
Yes.
The petitioner hearing the management of an educational institution. Respondent number 2 was a workman. The petitioner management. He was terminated from service. An industrial dispute was raised. And matter was referred by the appropriate government to the labor court. Learned labor court by its award, award dated 18/9/2017. Directed to reinstatement with full back wages. That was challenged before this honorable court by filing a petition, and the award was upheld.
Where is the impugn order? Annexure 13, where is that?
Right, here impugn order is mirrored. They have
Where is
filed
that?
one
Which page?
impugn order, Lordship will get at 101.
101.
Yes. It starts from 100.
Page 100.
Starts from page 100 and
Who is this B. Kalita?
My lord, Mr. B. Kalita was is the representative in of the respondent number 2 in the labor court. He is a member of the Indian National Trade Union Congress. The challenge, the reason why the petitioners first came before your lordship is that
No,
they're challenging.
he is, what is he?
He is, my lord, not just a member of the INTUC, that is Indian National Trade Union Congress. My lord may take up our affidavit, my lord. The affidavit that filed by the respondent number 2, my lord. He is
My lord, he has been holding the post of secretary in Indian National Trade Union Congress. And secondly, my lord, he has held office bearer of other trade unions as well. And he has been conducting industrial disputes, conducting cases before the industrial disputes for many years now.
Where is the,
Page number
no,
100.
no, where is the reference made by the government?
My
Which
lord,
page?
reference by the
Reference by the government for industrial dispute? Where is that?
reference for this particular dispute, my lord. I do not.
Reference was made or it's
There-
May I submit one?
Yes, my lord.
Reference was made. That
Where is that?
reference, order of reference is not there, but award is annexed. Award of
Where
the
is, where is that?
award lordship will get at page 98. No,
90?
Lord, award lordship will get at page 39. It starts from page 31, operative procedure. Page 31 start. The award,
31.
page 31.
No, 31 is not award, there is a
23,
repetition.
my lord. 23 is the reference award. Page
23, I'm sorry.
20?
31 is the High Court
23.
award. 23.
23 is the award. The terms of reference is in page 23 itself, whether the management is justified in terminating Sri Jayanta Soikia. If not, whether he is entitled to be reinstated with the full back wages.
Industrial dispute. Yes, where is the power to reference which represent?
Representation is
36,
section 36, you know,
Section 33,
section
36.
36.
36.
36, one is regarding workmen. Right? Representation of parties. Section 36, one prescribes the eligibility of representative for workmen.
Where is your affidavit saying that he is a member of the registered trade union?
My lord, page number. My lord, in page number 115. There is a signed document from the president of the Indian National Trade Union Congress Assam branch.
100?
115 of the affidavit filed by respondent number 2, my lord. My lord,
Yes,
on page
Mr. Holloway.
My lord.
Then if he's a member of the trade union, then he's entitled to represent.
No, my lord. My lord, may I refer to the section 36, my lord? once?
Yes, yes.
What section 36 says, my lord, the workman can be represented. A workman who is a party to dispute shall be entitled to be represented in any proceeding under this act by any member of the executive or other office bearer of a registered trade union of which he is member. The workman is to be member of that trade union. Any member of the executive or other office bearer of a federation
of trade unions to which the trade union referred to in clause A is affiliated. Where the worker is not a member of any trade union by any member of the executive or other office bearer of any trade union connected with or by any other workman employed in the industry in which the worker is employed and authorized in such member as may be prescribed. So, my lord, first thing is that the person who is representing, he must be executive member or office bearer of that particular trade union which is working in that particular industry. First thing, or if the trade union working in that industry is affiliated to some federation, here the Indian National Trade Union Congress is a federation. If the union which is working in that particular industry, that union is affiliated to any federation, an office bearer of that federation can represent. Or any executive or office bearer of the trade union of that particular industry, even if the particular concerned workman is not member, then also. But here, my lord, is B. Kolita herein, he is neither a member of any trade union working in that industry, and the trade union to which member this concerned workman is, that is not affiliated to Indian National Trade Union Congress. If lordship, I would like to refer to your one document, what was filed before the learned Labour Code. Lordship, may kindly have a look at page 103 of the petition. This is the authority letter the workman issued in favor of the B. Kolita. I, the undersigned of above case, do hereby authorize Sri Basanta Kumar Kolita, a trade union activist, who appeared before the Honorable Labour Court Guwahati previously for and on behalf of me, to file, attend, and conduct this case in the Honorable Court of your honor. So he's trade union activist, maybe, but the prescription as per law, he must be office bearer of that trade union to which this particular workman is to be member. That is not there. Nowhere it is pleaded that the workman is member of any trade union and that trade union is affiliated to Indian National Trade Union Congress, of which B. Kolita is office bearer. And apart from it, my lord, they have annexed one document what my learned friend has referred at page 115, the certificate. It says that he is a trade union activist. He is holding the post of secretary in our organization. But what section 36 says, concerned workman must be member of the trade union and representative is to be the office bearer of that trade union. If not, he is to be the office bearer of the federation to which that trade union is affiliated. Or the trade union working in that particular industry, the workman may not be member of that trade union, but that trade union must work in that industry. Nothing is there, because he may be trade union activist and the authorization, there is nothing, he is only simply it is made that he is trade union activist. But law says in another way, law says that he must be office bearer. He may be the office bearer.
That is the only point. You have any, you have cited any case on this?
No, my lord, right now,
Okay.
but the law is clear, my lord.
Yes.
If I may submit, my lord. My lord, before going into our submissions, I would like to bring some facts into the knowledge of your lordship. First of all, my lord, the workman was removed from service in August 2016. Since then, for the past 7 years, for a mere 8,000 rupees salary, he has been fighting for his claim of full back wages. In the reference case that was initiated before the Honorable Labour Court, this particular person, Mr. B. Kolita, he represented the workman. The same management did not have any objection at that point of time. So afterwards, they filed a writ petition. There also, they did not raise this objection. In the state of execution, when they fail to clear all the back wages, they are coming
Can there
and
be
paying.
any estoppel against law?
Secondly, my lord,
Can there be an estoppel against law? Can there be an estoppel against law?
no, my lord, there cannot be an estoppel against law. But at the same time, my lord, with regards to the interpretation of section 36, my lord, section C, it states that 36(1)(c). My lord, here the organization for which the workman was working does not have a trade union. So by the by that logic, he definitely cannot be a member of any union if his workplace does not have a union. So therefore, he'll be represented by somebody who is affiliated to that particular industry, right? So here what section C says, where the worker is not a member of any trade union, by any member of the executive or office bearer of any trade union connected with, or by any other workman employed in the industry in which the worker is employed and authorized in such manner. Now, my lord, the Indian National Trade Union Congress, my lord, there is a federation and there is I have a list of all the federation. They have the Indian National Salaried Employees and Professional Workers Federation come under them. Here the workman is a salaried employee. So under that circumstance, one section 36C will not be applicable to this to the workman. Moreover, my lord, there is actually a bar on legal practitioners representing a workman. No such consent was taken by the councils of the management while presenting the case. And if the objection is not raised at the initial stage, it will be deemed to be accepted. At the stage of cross-examination, my lord, this has been done. A writ petition has been filed before this honorable court, challenging the representation of the workman. Furthermore, my lord, I have a lot of case laws that can prove what I'm stating, my lord. My lord, I have a judgment from, I'll provide the case law copy. My lord, in the first case itself, it is stated that the right of representation under can be availed by a workman who is a member of an unregistered trade union also. But in this case, the person representing is a member of the registered trade union only. He's not a member of any unregistered trade union. It is amply clear from the certificate that is issued by the president himself, president of the trade union himself. My lord, para 4 of the first judgment, which is from Patna High Court, my lord. It states that on behalf of the petition, learned counsel submitted that Labour Code had committed a mistake of law in holding that section 36(1)(c) of the Industrial Dispute Act only applies to a case of worker who is not a member of any trade union, whether registered or unregistered. It was contended on behalf of the petitioner that section 36(1)(c) applies to case of worker who is not member of a registered trade union, and such worker has right of representation under the act by an officer of any registered trade union connected with the industry in which the worker is employed. In our opinion, the argument put forward on behalf of the petitioner is well-founded and must be accepted as correct. If an unregistered trade union member can employ, what is the bar in a registered trade union member representing the workman? The second judgment, my lord.
Yes.
In the second judgment, my lord, I'm reading from the head note, my lord, just to give a brief idea to your lordship.
I don't have a habit of reading.
My
head notes.
para 5 and 7. my lord.
Yes.
A reference at the instance of the union may not be competent, but that by itself cannot be regarded as sufficient to disqualify it from assisting the tribunal in the proceeding of the dispute. Section 36 of the Industrial Dispute Act bars the appearance of legal practitioners in conduct of its proceeding before Labour Court. But since reference case, the management has been represented by the legal practitioners only, without seeking due consent from the workmen. And under that circumstance, you are coming and you are challenging my representation by a valid member of a trade union society, a trade union, my lord. Therefore, legal practitioners in conduct of its proceeding before labor court and provision has therefore been made to safeguard the interests of the parties in cases coming before our industrial tribunal by permitting the parties to be represented through unions or authorized agents. Your, my lord, the workman has authorized the member of a trade union congress to represent him. Thereafter, my lord, the last judgment that I'm relying on. My lord, paragraph 18, this is a judgment from the Allahabad High Court. It is in paragraph 18, my lord. The last contention on behalf of the petitioner that the UP Industrial Tribunal wrongly permitted Tajamul Hussain to be represented by R.K. Sharma in the proceedings before it needs little consideration. Even if there was wrong representation before the Industrial Tribunal, the appellant had its remedy before the Labor Appellate Tribunal of India, and he could have sought vacation of the order of the Industrial Tribunal from the proper court on this ground too. There was a reference case, my lord, in 2017. Thereafter, they went for, when the award was there against them, they went to the Honorable High Court. They did not raise this option at that stage. They had an opportunity to do that. But now, when they are at the stage of cross-examination, they are before your lordship, challenging this, when they had ample opportunity to challenge that before. Therefore, my lord, on these grounds, I do not believe, I believe that the representation of the workmen is proper. Moreover, my lord, as per the last order, this honorable court directed the petitioners to pay a sum of rupees 1,88,000, deposit a sum of rupees 1,88,000 before this honorable court. They have done so on 31st of May, my lord. My lord, I have a list of affiliations of Indian National Trade Union Congress that I want to place before your lordship, my lord.
Give a copy to Mr. Haloi.
Yes, my lord. My lord, another point that is important to
Yes, yes, sir.
yes, ma'am.
Yes.
Yes, my lord. My lord, here the section 36C says that connected with the same industry. My lord, herein the definition of the industry, if I may just go into it, section 2J, section 2J states that industry means any business, trade, undertaking, manufacture or calling of employers and includes any calling, service, employment, handicraft or industrial occupation or avocation of work. Here, my lord, service, employment, the words are mentioned. The industry, it is not a dispute that this particular industry comes under the management. It comes under the industry of service and employment. The Indian National Trade Union Indian Congress has a federation for all salaried employees. Thereafter, how can you reject, how can the management say that he is not a member of the connected trade union industry, my lord? Moreover, my lord, there are records available that this particular man has represented various workmen before the labor court. This is the first of its instance where his representation has been challenged.
May I submit one thing? But my learned friend has referred that regarding industry, etc., this is not the issue before in this proceeding. We are not disputing that also. And his workman that has attained finality, we are not disputing that also. So section 36(1)(c), what my learned friend is submitting, that he is to be member of that what is saying that salaried employees federation. What I am on, my lord, this concerned workman is to be member of that trade union, and that is to work in that industry. There is nothing.
No. Even if he is not a member,
Yes,
he'll be entitled to protection of 36(1)(c).
he is entitled to protection, but there must be a trade union. He may not be member, and that office bearer of that trade union is to be present, or the federation to which that trade union is affiliated. So this prescription is to be followed, my lord. And this particular gentleman is representing in many cases, many workmen. Maybe I am not on that. If he falls under section 36(1), then he can.
You see, it's an unnecessary exercise which you are calling upon to do, to the court to do it. You see, come to 36.
Yes,
So the only defect is that letter by which he says he trade union activist.
activist.
If the petitioner, if the respondent files a authorization letter saying that this B Kalita, he is the what you call secretary of the federation, and this federation is what you call, he is affiliated to this salaried employees association. Matter.
But salaried employees association, what my learned friend is referring.
No,
It's
if he is not a member, 36C says if he is not a member.
Yes, if he may not be member. Lordship, may I read the section 36(1)(c)?
Yes.
Whether worker is not a member of any trade union by any member of the executive or other office bearer of any trade union connected with or by any other workman employed in the industry
So
in
industry
which the worker is employed.
industry is a service.
So that trade union must be working in that industry. He may not be member. I'm not on that. He is entitled to have that protection. But that trade union must have the existence in that particular industry. That is not. Trade union for a concerned worker may not be member of that trade union. But that trade union must have activity in that particular industry. That is not.
No, activities, the act doesn't say activity.
No, my lord, what it says, any trade union connected with or by any other workman employed in the industry in which the worker is employed.
Hmm.
So that trade union must have existence in that industry. This is first time that my learned friend is referring to this, but
If the
this,
employer is not a member of any association of employers, by an officer of any association of employers,
no, it is for employment section 36(1)(c).
sorry,
36(1)(c).
see, 1C, where the
1C.
worker is not a member of any trade union, by any member of executive of, or other office bearer of any trade union connected with, or by any workman employed in the industry in which the worker is employed. So any trade union can jump in.
Any trade union connected with that particular industry, my lord.
You see, when she is submitting us before us list of federation,
Yes,
that-
my lord.
Indian National Salaried Employees and Professional Workers Federation. So they deal with this salaried employees.
No, my lord, what I would like to submit, so far my limited knowledge is concerned, this trade union in industrial establishment, there are trade unions. And that trade union may be affiliated to some federation. There are numbers of national trade union federation in India. Indian National Trade Union Congress is one. Indian National Trade Union Congress has, what my learned friend has submitted, this Indian National Salaried Employees and Professional Workers Federation. This is a constituent trade union of, this is also federation, but I'm assuming that it's constituent trade union of Indian National Trade Union Congress. But this trade union must have existence in this particular industry.
In the trade, doesn't say in your organization.
Yes.
Supposing I am a trade union activist, you, from your argument, it will be as if you want my interference in your day-to-day activity in your establishment.
No, my lord. That is not what my submission is, my lord. The trade unions in industrial establishment, there are numbers of trade unions. It is not that only one trade union is working in one industry. Numbers of trade unions are there and they are affiliated to different federations. So, any of the trade union, but this trade union must have existence membership in that industry, because trade union, there must be subscription of workers.
It's an unworkable argument. C says when worker is not a member, so if the worker is not a member, he can't be a member of the of that trade union.
Maybe.
In
But
that,
what section 36(1)(c) says, he may not be member, then by any office bearer of any trade union connected with that industry. But this trade union does not have any existence in this industry.
How would you say it? One is connected with the industry. What is your definition of
Connected
connected with the?
Connected meaning, thereby, my lord, what I understand, that in trade union, as per Trade Unions Act,
He should have
the-
given a dharna in your establishment.
that is not,
anytime.
that is not. Trade union, one trade union works in particular industry, meaning thereby connected in with particular industry, meaning thereby some numbers of workmen have to subscribe the membership of the trade union. But trade union access subscription is to be there. Without any member in any establishment, it cannot be said that that particular trade union is connected with that industry. At least one single member is to be there.
You see, the words are connected with the industry, not industrial establishment.
Connected with the industry. Yes, my lord.
With the
Connected
industry.
with industry.
Industry is a generic term. It will encompass all everything.
But industry, what section 2J says of industrial.
If somebody says establishment of the court, correct.
No.
This means limiting to people who are working in the court. If people say that he's a association of salaried employees may be XYZ, even as a lawyer, Mr. Hallo is what you call employee.
Clerk.
Not clerk, I will not say clerk, but your employee otherwise would, if you fall within the meaning of definition of industry, then even your employee would become entitled to the protection of the union.
Well, yes. But what section 36(1) says,
It's not necessary that the presence of the union must be demonstrated by having at least one member, because then the law would have, the
trade
prescription would
union,
have said
one
that.
trade union connected with one industry, that trade union must have some members. Otherwise, how a trade union is connected with the
You are almost
industry?
to show that Because you see, the law doesn't say that one has to be a member.
Then my lord, this document has for the first time come in. So lordship may fix it on some other day, I will appreciate your lordship.
Because you see, let us say that somebody is running a medicine pharma,
Yes,
pharmaceutical industry. And there is a trade union which says so and so pharmaceutical, it is engaged in pharmaceutical works. So therefore, it's not necessary that the pharmaceutical works X, any member has to be a what you call member of the federation or the trade union, then only others will be covered.
regarding
It,
this,
it runs contrary to the labor protection laws. You take time, you show us.
lordship may fix some on some other day, and
Okay.
my friend may bring it on record, my lord, if this
I will file an
particular trade union
You
is
bring it on
working.
record.
Yes, ma'am. I'll do.
Bring it on record.
So we bring it on
Sure.
record.
Both sides are duly presented. The learned counsel for the respondent number 2
Yes,
prays for
Thank you very much.
and is granted time for affidavit to bring on record the activities of, sorry, the natural affiliations that INTUC has. Pushpa. The learned counsel for the petitioner prays for some time to take instruction and to file reply if so required. He is so advised. Text para. Affidavit within 2 weeks.
Yes.
Affidavit by the respondent number 2 shall be filed within 2 weeks. Reply if any within 2 weeks thereafter.
Right.
This is the matter after 4 weeks.
Much-
Much obliged.
You are there for? Or with you? Okay.
much.
Your cases, take it back.
May it pleases you, lordship. Here, we need to file affidavit, your lordship. Affidavit is ready, your lordship. We have sent it for vetting, your lordship. Kindly 10 days may be given, your lordship, to file.
10
file
days.
that. Yes, your lordship, 10 days.
And the dates will be fixed. My lord, earlier occasion they have taken time to use.
Okay, give a date after 10 weeks, 10 after
10
10
days.
days. Both sides are duly represented. On the pyramid by standing counsel for BTC.
I'm appearing for BTC, your lordship, 2, 3, 4, 5, and 7.
This after 10 days, so never had to file affidavit in opposition to the
I
matter.
am appearing on behalf of 1 and 6 lordship. 1 and 6 lordship.
For respondent 6. Additional senior matter.
28. 28.
Deeply obliged.
34. May I please confirm? On the last of the respondent took time for file affidavit. No affidavit file will do the matter.
Yes, no affidavit, you proceed with the matter then. But you see, you are challenging the what you call the promotion made in 1996.
Reverse on mine. Reverse on mine.
Yes. So 96, the challenge of 96 today, would it be maintainable? When you have allowed the what you call the status to be changed.
He filed my lord, RTI and in 2016, RTI reply have filed. From that he filed that he since that he is senior than the other person.
No, but you see, that is 1996. You have allowed that position to continue for how many years? 27 years.
Yes, ma'am.
After 27 years, you want us to put you senior to the respondent. Can it be
The
done?
respondent filed a reply, RTI reply in India, RTI reply. They stated that petitioner is
No,
senior.
no. Can we change the situation after 26 years? You, for 26 years, you allowed that status to be maintained. After 26 years, it would be, even if you have a case, it would be, equity will be against you. Because equity has accrued in favor of the private respondent. You are not filing your affidavit, why?
Lordship, our affidavit, we are filing today, Lordship, today itself. Lordship.
Today?
Yes,
Because you'll have to file it.
it's ready. Lordship. We filed it.
Okay, both sides are duly represented. Mr. P. Nayak, standing counsel for BWD, submits that he is filing an affidavit in opposition in course of the day today. List on Monday,
Lordship.
list on 21/8/2023.
My lord, I have some personal difficulty. Can be listed after 27.
After 27th,
Friends.
then 28th,
Oh, yeah,
28th.
published.
But you'll be prepared on that issue of equity in favor of the private respondent.
35.
Lord, in this case, Lordship, instruction awaited. 35.
No, if he, because you'll have to only take instructions whether he is eligible, he's in the zone of consideration. If
Lordship.
that be so, then the next DPC, case has to be considered.
Lordship, already communication has been sent, Lordship. We are just waiting for the instruction.
Okay. When should we fix it?
Lordship, take up after 2 weeks, Lordship.
Lordship, it may be fixed, please. Can it be on 28, Lordship?
Okay, list on 28/8/2023, so as to enable the Mr. P. Nayak, standing counsel for PWD to obtain appropriate instructions. Next, the PWD authority shall also examine if the petitioner is in the zone of consideration for promotion. As to whether the petitioner is in the zone of consideration for promotion and whether his case will be put up before the next TBC. Next, this for 28.
36 to 38. Sewerage board employees, my lord. They were not getting salaries and there was a scheme. The lordship may kindly see the order dated, last order dated 31/7/22.
Yes, what is your instruction?
Commissioner, instead of commissioner, joint secretary has filed. He is not saying anything.
No, no.
I'll say commissioner, what he has said from the paragraph 3. He is not commissioner, joint secretary. Your lordship directed commissioner to file the affidavit.
On behalf of the
No,
commissioner.
no, on behalf of the
Yeah.
commissioner, Miss Mellon.
Yes.
When court directs my lord to commissioner to file, and what he is saying, my lord, that in response to paragraph 3, paragraph 3,
Which affidavit file when?
affidavit file. Well, I got a copy on 11/8/23, I think.
That's not here. In which case you have filed affidavit?
Yes, in item 36, Lordship. WPC 1989/2023.
Let me see your copy. We don't have it here.
That note is also there.
I'll not read that.
Sorry, your lordship, maybe.
One of.
All evasive. Your lordships, paragraph 6 is to inform the court as to which authority shall be disbursing salary to the petitioners who are stated to be engaged in Silchar water supply scheme and are presently working with the Assam Sewage. A specific notice is being issued because the learned senior counsel for the petitioners has submitted that the petitioners have not been paid their salary from June 21 to 50. On salary part, they are totally absent. They say
No,
they are silent of the matter. I don't know how the commissioner
Yes,
makes schemes.
Paragraph 3, Lordship, in my affidavit, Lordship, categorically stated that the liabilities therefore rest with the Silchar Municipal Board.
Silchar
Mr.
Municipal
Goswami.
Board says
Mr. Goswami, let us say that para 3 reveals the intention of the government, correct? But the person from whom Mr. Das is representing, is he not entitled to know that his salary will be next received from by a writing that his salary will be next received from X? Who becomes the appointing authority? Who becomes the disciplinary authority? If he has some grievance, who is the authority? Who will be the controlling authority?
Lord, I'll just say one line, my lord. They say, my lord, salary will be paid by Silchar Municipality Board. Silchar Municipality Board said we have no money to pay. And finance, my lord, they filed an affidavit saying.
No, there is
that-
a good news. In fact, yesterday or day before yesterday, there was a good news. In Guwahati, one person was caught printing money.
Hello.
I think they
Finance
will have to buy
department-
just that machine.
Finance department can get hold of that machine and. pay it immediately.
Mr. Datta,
And my lord,
you take permission from Mr. Nayak next door, your next neighbor.
He is the person who has to do
And
that.
Finance department says, my lord, finance
No, you
department
see,
says.
Mr. Nayak, it's a simple thing. Mr. Das is agitating a cause which is otherwise very simple. His employment, he is an employee of this urban water supply initially. No. Let us say he was an employee there, correct? Now, the government thinks that it would be appropriate that his services are transferred to Silchar Municipal Board, correct? Can employment be transferred like that? Number one. Number two, the same 3 questions I asked earlier. As a if one is a salaried person, is he not entitled to have an order that his next salary will be drawn from X?
That is the only confusion. In fact, not there is a board called Assam Urban Water and Sewerage Board. This board runs water supply scheme in all throughout the state of Assam. Under these petitioners were engaged under this board on work choice basis and must all basis. They get their salary from the revenue earned from the water supply scheme. Now, recently, government has decided to hand over these schemes to the respective municipality, along with man and material stuff. So these schemes has their own revenue earning. And it is the understanding that from that revenue, the employees will be paid. And I have the calculation, Lordship. There is sufficient earning of this Silchar Municipal Board from this scheme, Lordship, to pay monthly salary. Lordship.
What we'll do is, for the time being, till you do your arithmetic, we direct that the finance department pays to them and deduct the amount from Silchar Municipal from their Silchar Municipal Board from their grant.
Right now, Lordship, with my information, Lordship, a meeting with the deputy commissioner has also took place, Lordship. Now, right now, he is controlling the municipal board because it's not have a elected municipal.
No, just tell me today.
So
Just tell me today.
Lordship, this issue has been resolved.
No, it's
by-
okay. Just tell me today. For persons whom Mr. Das is represent him today. Today evening, who will give him the bowl of rice?
Lordship, that issue has been resolved, Lordship. To my information, Lordship, my senior colleague is also here, Lordship, he is representing the Silchar Municipal Board. A meeting with the deputy commissioner and the commissioner housing and urban affairs was today. There the issue has been resolved.
Has been resolved.
To my information. Now, my senior colleague is here.
I'll just take your lordship. In my affidavit page 6. if you-
Well, I just want an assurance, who will feed,
No, they went for picketing, they were arrested. No, look at the plight of which. they
it's
are-
okay,
My lord, we
I
have
just,
7586, my lord.
just a moment, let me say,
No,
that
there
I
is, a
complete this
decision
part.
is there. The decision is there. Even if the schemes are given, the salaries will be paid by the, my lord, urban. And thereafter, my lord, that is why in the final order that was passed, which is.
No, let me see, there's a meeting, he has the information.
No,
Let
that is
me
for
hear it.
Silchar.
Meeting, my lord, offer acceptance of these employees, it's okay. But then where from the fund will come? Now, in that regard, my lord, your lordship, if my affidavit is on record, your lordship can see the paragraph 6. What is
Affidavit
our
of?
position? My lord, our affidavit.
That we have last time also.
My lord, that affidavit recently we have filed.
Acha.
I think it cannot be in the records. The extra copy I am just. What is our financial position? We have enlightened them.
No, you see, that doesn't help me.
No, unless.
I'll
the
tell
fund
you,
is-
I'll tell you why
Fine.
it doesn't help me. Number one, insofar as the municipalities are concerned and the state government is concerned, there is a system which is called deficit finance budgeting,
Yes.
correct? So therefore, from how and where you get the money, we don't know.
The
And
provision
therefore-
is there in the constitution, I think article two
My lord,
forty-three Y.
constitutional obligation with the state is
No, no,
there.
no, no, what I'm
Your
on,
lordship-
I'm on different thing. You see, so therefore, your status of a budget
Well,
doesn't display a true picture. Because what happens to your deficit budgeting, what you call proposals? Therefore, looking at your budget will not help me
my lord,
when it comes to state and when it comes to municipal boards.
Your lordship is very right, but the question is, my lord, all the municipalities position, financial health position, everybody is aware. Now, in these financial burden, so far the municipal board is concerned, well, it is more than 3 crores and not so far the retired employees benefit. The case is pending before this honorable court. Your lordship also heard once that matter. Now, in the other matters, 5 crores, 550 lakhs, these are the, my lord, pending financial burden.
I understand.
Now, these additional burden, if it comes, my lord, where from we shall pay? And your lordship, we shall, when we shall not be able
Just tell
to pay.
me, has the Silchar Municipal Board or Municipal Committee never applied before the state government for release of any grant?
My lord, we have taken up the matter with the commissioner.
So that
letter-
is why.
We have
from- no, no,
intimated them also.
Your question stands answered. If you have requirement of fund, write to the government for funds.
My lord, that is the letter, if your lordship find in this affidavit at page 139.
Because you see, these are questions where the court has no solution.
Very correct, my lord.
So
I do
therefore,
appreciate that.
we can only give a direction that you will, whoever takes the burden will pay the salary of the current salary of the petitioners, what you call, without fail.
My lord, that's true. My lord, in that case, what will happen? Your lordship will pass that order.
To stop construction of roads, stop all development activity.
My lord, all the
2024 elections
sanitation
are
and all
coming.
that-
No, 2024 elections are coming. So instead of repairing the road, give salary to them.
My lord, if your lordship kindly look at page 139.
139.
The
Because when
letter-
it comes to salary, we have sympathy only towards the people who have not received the salary.
No, exactly, I.
How the state will get money is the state business. They can give a golden handshake, end of the matter.
Your lordship take it too, because the time is, I think, over.
No, let us see what.
Yes,
the-
yes, my lord. It's a letter to the commissioner and secretary to the government of Assam. With reference to the subject cited above, I have the honor to place before you the financial liabilities of Silchar Municipal Board and requirements of government fund for urban water supply scheme Silchar. That Madam Silchar Municipal Board is running under tremendous financial.
Your last paragraph is okay. In the meantime, I have read it.
My lord.
Last paragraph of the letter is a good suggestion. That is what came from me.
Right. Now, in this view of the matter, unless the fund comes, ultimately what will happen? Your lordship will pass an order. We shall not be able to pay. Then they will come up with a contempt proceeding. The
Then they will
executive
pay.
officer will face that.
Then they will pay.
Then also they will not be able to pay. There is no fund at all. Your lordship has seen what is the deficit budget here.
You see, I am a wrong man to make that statement. Why, you know? The major part of the life was in the civil court. So when any payment does not come, we file an execution petition and attach the deputy commissioner's property.
Everything will be in line.
So therefore, if you can't pay, you sell your assets.
Is sufficient. Employees of the municipal court are different from the employees of the this scheme lot.
No,
One
this,
example. I'm
you see, I'll tell you, you have a tap, you find out the, the case of Frontier Construction Company. It's in a different context. It was a contractual obligation. But the law laid down by this court was that insofar as the liabilities are concerned, Mr. Das will remember that case, Frontier Construction Company, where fact in issue, I'll tell you, this AACB at that point of time gave the Karbi-Langpi hydroelectricity project to Bharat Hydro Power Corporation Limited, and said that we are giving you this asset with all liabilities. So Frontier Construction Company, who was required to get money from AACB, he approached this court saying that no, I can't be subjected to recovery of my dues from this Bharat Hydro electricity project, because when my dues was there, it was with AACB. And this court held to that effect that it would be the AACB who has to pay. The liability cannot be transferred. So that is the law laid down by this court. Now the question is, same argument will come here. Number one, today there is a dues receivable by Mr. Nair and Mr. Das. Correct. The liability to pay that debt as against salary would lie on the department where he was working. That can't be shifted to some other person, because now this question has come.
We are not
Mr.
shifting, just one example I'm giving. I'm showing the figure of January 2023. The earning from the scheme in the month of January 2023 was 18,60,133.
Correct.
For payment of salary to this around 40 employees.
Only simple thing has to be done.
Around 10 lakhs.
No, Mr. Nayak, a very simple thing answer. Answer is very simple. You have seen the affidavit of Mr. Datta?
That was an earlier.
No, it's okay, but the current affidavit where he says that he requires funds from the government. Correct. No, let me finish. Mr. Datta's stand is that from where he'll get the money, so therefore he has written to you for grants in aid. According to you, he has already earned 18 lakh rupees and could have given salary to Mr. Das.
Yes.
You log an FIR. Send a vigilance today. By evening, they will raid the establishment of Silchar Municipal Board and find out where the money has gone. Very simple answer. It can be done in 1 hour. So just lodge an FIR. Ask your authorities to lodge an FIR.
What is my instruction? Is
No, instructions are very okay.
3-4 days. Meeting to
Instructions are okay. But what happens in reality? You see, if I have a urge to have my meal right now, I can't postpone it for 4 o'clock. After 4:30 when I rise, I'll have my meal then. Doesn't help me. So the question is that if he wants a salary to be paid, you just tell us from where he gets the salary. Give it to Mr. Das. Either you take it from this 18 lakh which has been earned. The state finance will. So today, shall I pass Mr. Nayak will resume at 2. Correct. By 2, get me an instruction that 18 lakh rupees which you say Silchar Municipal Board has earned should we pass an order right now today at 2 o'clock attaching that money.
Just 1 minute, I'm taking. As I'm referring to the meeting again and again. Let my learning senior take instruction for the deputy commissioner.
No. Since you are saying that they have already earned,
They are
just
regularly
tell
earning.
me.
These are the figures.
No, it's okay. I'm not disputing you. I'm readily agreeing without even going through it. Now the question is just taken information whether this 18 lakh rupees I can attach at 2 o'clock. Yes. If they want the money, we'll attach it. And then we'll come to Mr. Nair and Ms.
I'm not with
Devi.
Silchar.
No, I'm said after I finish with Silchar, then we'll come one by one to these people. So so far as I am concerned, to tell us a scheme by when the salary would be received. I've told you the case law of Frontier Construction Company. The liability, current liability, I can understand. But past liability, you make a settlement. We'll say the finance will have to.
Covering all this issue also possibly done in 1 week time.
At 2 o'clock, in the meantime, we'll take instructions.
Instructions also there. One affidavit.
We'll see that. Let me come at 2. We'll see that instructions.
The revenue earning by the Suez board, my lord. Now I have sent to my client, my lord, I just told them to make an assessment whether it is sufficient to pay the monthly salary of the employees.
Let us assume the answer is no. Let us assume the answer is no, it is not sufficient.
My lord, with all respect, I would like to say, the answer won't be emphatic no. Because there may be deficit of some amount, but it is not an emphatic no. Because some earning is there, what I've seen from the chart. So it is, my lord, monthly, sometimes it is 13 lakhs, sometimes even 3 lakhs.
But
In average,
Mr. Datta, you see, I am troubled with the fact that the 3 questions which I initially asked. If Mr. Das is working somewhere, he must know where he is working.
yes, very,
Who is his employer?
Right.
And what are the terms and conditions of his service? The second part is, the other 2 questions were that number 1, who will be the disciplinary authority, who will be the appointing authority? This has to be clarified.
yes.
Otherwise, it's difficult for someone to be serving without knowing where he stands. He may be a contractual employee, he may be a temporary employee or whatever his status be. But someone must take responsibility of the petitioner being engaged. That is number 1. The second is at this stage, what appears is that you are all under negotiation, you are doing negotiations with each other, trying to sort out the issues. By all means, do it. But the fact remains that who takes the responsibility of paying the aerial dues which are to be receivable by the petitioners?
Area will be by the earlier department.
Earlier will be by the other department. Then please tell me, what would be the cutoff date for the this urban water supply to make payment to the petitioner? What would be the cutoff date? And since which date that responsibility will be taken over by the Silchar Municipal Board or other municipalities in the state? What is the date?
Your lordship is indicating about current salary.
No, I don't know current salary because supposing you take over the water supply with effect of 1980. We don't know the government how it functions. Let us say that you take over the water supply board since 1980. Then the entire area will be at your on your shoulder. If you say that I have taken over on 1st August of 23, then it will be a current liability.
Yes.
So therefore, what is the date on which liabilities will shift, or it will be retained by the Assam Water Supply Board?
Lord, in order to clarify all these things, my lord, can I seek just 1 week time, my lord?
You see, giving time till 30th of this month, there is no issue. But on 31st, the payment of the petitioner becomes due. The question is that whatever time you take, Can you give us the code, ultimately you will have to give us an assurance that on this day where the payment should be released by X, Y, or Z. And the-
Only one thing I
yes.
just like to point out, your lordship may see page 139. The letter of the municipality board. I think the matter has to be resorted to by the commissioner of this housing and urban affairs. And the letter has been addressed by the executive officer. And your lordship got 139. That
No,
affidavit
I have
filed
seen
by the
that, no, but you see, these issues are to be sorted out
Yes.
at the
yes,
highest level of the
At
government.
the highest level of the government. That's what,
But this,
because municipality has written a letter saying that the salary is about 13,75,000 per month. And that middle portion of the, I'll just. write
I'm
this.
seen there, I'm there.
Yes, that in pursuance to the above mentioned facts, I would like to highlight some of the important issues of Assam Urban Water Supply and Sewerage Board, Silchars employees benefit. That madam, collection of the water supply scheme from 1/2/22 to 36/23, that is for about 6 months. 1 crore 25 lakhs.
4
rupees,
months.
so and so. Madam,
1,
Yes,
2.
yes. madam, 4
No,
months.
sorry, no, not 4. This is 12 plus 2, 14, 14 months.
14 months, yes. 1 crore 25 lakhs, but the salary which
18
the
months.
employee stands at 13,75,000.
February to June 23 would be 16 months.
Yes, 16 months is 1 crore 25 lakhs and salary per month is 13,75,000. And my friend, my lord, from the finance department says 18 lakhs is lying. And 18 lakhs is nothing. It's a 13,75,000 is the my lord, payment due per month. My lord, it seems my lord, nobody is applying their mind in the whole affairs. They made a scheme and tried to shift the burden to the Silchar Municipality Board, who themselves says that, my lord, they have got dues to be cleared about 5 crores 50 lakhs rupees. Their own dues. So under the provisions of the constitution, my lord, I think it is 243Y. It is the responsibility of the government to make the deficit amount to the municipality board. It seems, my lord, they are taking responsibility from 1 to 22. My lord, merely the commissioner, he has made a scheme. Now he is not coming before the court also. He is sending his deputy secretary to sign the affidavit.
That's a different issue, my lord.
No, that is also. an
No,
issue,
no, you see, these are relevant issues. And very pertinent. The reason being, what Mr. Das is now showing, the income of water sewerage board at Barak Valley division is the income was for this 16 months, it was 1 crore 25 lakh 49,341. Correct?
440.
Yes, 441.
441. So now if we do the calculations, let us say 125, 49, 441 divided by 16 months,
Yes.
Yes.
correct? Divided by 16 months is 7,84,350.
Another 7 lakhs deficit per month.
And this employees is 13,75,000. 1375. So there's a deficit of about 6 lakh rupees a month, so 5,90,659
Yes. Per month.
per month.
And their salary is due for, my lord, your lordship has reflected in the order. Their salary is, my lord,
Therefore, unless somebody takes a decision,
January 21 to January 22, then again, my lord, January 23 till date.
yes, Mr. Nayak, how do you propose to?
No, let them, I think your lordship will have to give them time, let them come back on Monday again. But
Monday,
they have
nothing is
not
happening
applied their
because
mind.
15th August is there. There are 2 days, nothing, no work is going to happen.
Our calculation.
They have totally not applied their mind. Well, they've just made their scheme, forget everything.
That is the potential lordship. Every month, Silchar Municipal Board should earn around 13 lakh. rupees.
Under Silchar Municipal Board, there are only 2,389 households,
Yes, Lordship.
only.
In this particular scheme, Lordship, whereas the capacity is 8.1 MLD, Lordship. And the utilization is right now, Lordship, 4.5 million only. So huge potential is there, Lordship. And right, so far as this list is concerned, Lordship, 43 employees are shown, Lordship. Right now, only 36 are working.
No, you see, Mr. Nayak, all these calculations, what are the potential doesn't help the court. The petitioners are before the court saying that their salaries are not paid. So what is the potential, what can be generated is something which is already only what you call
My
hypothesis.
only ground for showing this calculation is Lordship, Silchar Municipal Board should earn this much amount from the scheme, Lordship. If they are not earning, Lordship, it is the responsibility of the employees, Lordship. It is the responsibility of the employees.
No, you can't give that responsibility to the
But
employees.
we are not shifting,
I'll
Lordship.
tell
It
you
is-
very simply, let me tell you,
Lordship, revenue collection.
I
is their
understand.
responsibility.
I understand. Today, you see, everything is statistics,
Lordship.
correct? At one point of time, people made statistics, collection of statistics and said, the sugar level will be, if it is more than 100, it will be, he's a diabetic. Now the same authorities who had made the earlier, what you call calculations, permutations, combinations, they are now saying that 140 is the blood sugar level. You see, if you want statistics for every solution, you take a call, you do a statistics collection, and you'll find all sorts of records. Now, just tell me one thing. If everything is dependent on statistics, why on earth is the government making a deficit financing? They will say that the amount of resources which this government acts has, the potential is 1 crore rupees. Every day we have to have an income of 1 crore rupees a day. And if you don't earn 1 crore rupees, it is these employees who are what you call they are bad. Now, if they are bad, you shut them out. You make a law which says that the potential, if it is not achieved by a government servant, entitles him to be dismissed from service.
You want to them.
That policy decision will not take.
Lordship, at this stage, what I am submitting, Lordship, as my Lord.
No, but you tell me, you see, you are accusing someone
No,
saying that
accusing,
they are
Lordship.
not
I am
working
just-
up to the potential.
I am just showing the potential.
No, I understand, but does the government work on potentials? The government runs on the, it's a deficit revenue based accounting system. Today you want that you will give, you will dole out X rupees of money just before the elections. Let us assume it, that you are doing it. I'm not accusing you that you are doing it. I am saying that the government now proposing at the time of elections that this is the money you will dole out. Then what you do? Then you look at the revenue where it can be generated. Okay, wine, what you call liquor. Everybody drinks it, they make the excise to 500%. Somebody drinks, takes a cigarette. Okay, dislike it, make it 600%. And you tax the public on the basis of your financial requirement. So is the government, any policy of the government works on the basis of potential?
My lord, your
Yeah,
lordship,
Lordship,
may kindly
the
see
number of
Article
user is fixed.
243Y.
243Y.
I think my learned friend from the finance department is submitting without any, my lord, proper instructions, man. 243Y, these are the basics, man. The Finance Commission constituted under 243I, your lordship got why, your lordship got it, man. The Finance Commission constituted under Article 243I shall also review.
No,
the
Mr. Das,
financial-
I'm asking so many questions for a different reason.
Yes.
It's not because of this. Now you see what is happening is the government is giving that scheme to that Silchar Municipal Board.
Silchar, not only
No.
Silchar, all over.
No,
the
I'm just
Assam.
saying your case. Let us concentrate on Silchar Municipal Board for the time being. The scheme is given over to the Silchar Municipal Board. Now the question, the first question which I was asking was that you are whose employee? Number one, if you are an employee of the Silchar Municipal Board, then I understand 243 is okay. Then I understand 243 is okay. But if you are not made an employee of this of the Silchar Municipal Board,
Yes.
and you are merely an employee of a scheme, then your existence is coextensive with that scheme. Today, the government wants I close down the scheme, your employment goes. So therefore, 243 doesn't help me. My question is directed to understand that you are whose employee? Because you see, Mr. Nayak is saying,
By the sewerage
No, no,
department
no.
of the government of.
Mr. Nayak is saying that you have the water board has the potential of earning X rupees. If it is not being earned, that means the employees are at fault. Correct?
Yes.
Now the question is that whether the
Let it
it
go
is
down in the record, my lord, his submission. I will show what is there. Ma'am. Which officer is not earning to the, my lord, the
no,
desire
that
of
is
the, my
no,
lord,
no.
scheme.
I know that
Let
you
it
lead
go
to
to
a
the
Pandora's
scheme.
box. No, but you see, that is not the issue. I'm not in specifics, but the question is whether the employment to you was given on the basis of the potential achievement scheme. That unless
Your
you
lordship will see the
achieve the
scheme.
target, you would not be paid your salary. That is not the condition of
That is
employment.
not the case, my lord. This is a submission from the learned council, from where he gets it, I don't know. Whether on instruction, your lordship will see the scheme, my lord. That page 106.
106.
From where he is submitting, my lord, I don't understand, my lord. 106. Either, my lord, has not gone through the records or doesn't understand. For better functioning of the urban water supply schemes, lordship has seen that 106, I'll read it again. For the better functioning of the urban water supply schemes, the state government desires that all urban water supply schemes currently run by Assam Urban Water and Supply and Sewerage Board are to be taken over by the respective municipality board. To that end, you are directed to make necessary arrangement for taking over of Silchar water supply scheme with all man, materials and liabilities by Silchar Municipality Board. A detailed note on the man, material and liabilities of Silchar water supply scheme is attached here. And attached here it is this to the executive officer 107. In page 107, in view of the above government order, the man, materials along with liabilities of Silchar water supply scheme. This is a peculiar functioning of the government, my lord. So I'm a government official. I don't blame the government, my lord. Supply scheme has handed over to the Silchar Municipality Board. The amount of revenue already collected in the account of Managing Director Assam Water Supply and Sewerage Board amounting to rupees 8,90,000 only will be credited to the account of Silchar Municipality Board. So this is the scheme. Then again, my lord, 108, your lordship will kindly see, my lord. 109, my lord. In pursuance of the decision taken in the meeting chaired by Honorable Chief Minister Assam, so and so, will partially hand over the running scheme to the urban local boards and concerned ULB will bear the cost of electricity bill, chemical and maintenance bill of such schemes from the available fund under the 15 Finance Commission tied grant aid. So and so will continue to operate and collect revenues until these schemes are fully handed over to respectively. So now therefore, what your now page 110, I think, not page 1.
No, this you have shown us on the earlier occasion.
This is
but
a
the-
scheme made by them and accordingly it has been handed over, but they have not decided who is going to pay salary for all these years. So this is a simple case, my lord, where the commissioner of sewerage and my lord board, they have not acted with my lord, application of mine. Silchar Municipality Board, I do not my lord, blame. I do not blame the finance also because it is the matter, this commissioner of the sewerage board has to take up the matter. He has just written a letter. I don't know from how he has become commissioner, just written a letter saying that it has been handed over to Silchar Municipality Board. So as your lordship has raised questions, who is going to be the, my lord, the controlling officer, who, where, from which date the sewerage board will be responsible and from which date the municipality board will be responsible. How the municipality is going to get the deficit amount. All this thing has to be worked out by the, my lord, at an official level. This has not been worked out. Simply application, non-application of mine, some joint secretary has been sent for filing an affidavit. Commissioner is sitting tight. Let his salary be, my lord, stop for a month, he will find out. This man,
Mr.
and
I
now,
can,
my
sir,
lord,
Lordship, just one page I am showing, Lordship, in that bunch of paper, Lordship will get one letter dated 11/8/2023, Lord. 11/8/2023.
11/8/2023. Yes,
Serial number 5.
yes.
Instruction.
Board is handed over to the Silchar Water Survey with main materials as per direction of government. The instruments for Kape enclosed. The staff study of Silchar Water Supply Board will be borne by from the revenue of the scheme. Where is that letter?
That is not yet in record.
No, you sir, you just ask them to give you the copy of the letter from which date the Silchar Municipal Board is taking up. We'll pass the order today. We close the matter then.
Lordship, that affidavit come. Lordship. It will be
No,
clear.
no, you see, there are two things, Mr. Nayak. The government has to speak in one language. Now, the fact is, you are saying by producing a document of the Assam Water Supply Sewerage Board that this scheme has been handed over to them, correct? This letter is by executive engineer.
Urban water, supply.
Yes,
They have handed over.
no, it's okay. So they have handed over. So you just give us the date on which it is handed over. You take half an hour, you can speak to people and tell me. So the matter will be closed today, the writ petition, saying that the date on which they have handed over, they will arrange for funds, if not by getting grants from the government.
practice, what is happening, I stated on last occasion, in practice, they're still working from the sewerage board. Some amount of money they got it from the municipality board.
No, it's okay. You
In
see, there is a
practice,
judicial
this is
order.
What is happening?
If there is a judicial order saying that on this particular date,
Yes, you have.
the
judicial order,
liability
but
will be of the Silchar Municipal
The
Board.
salary has to be paid immediately, Mala, otherwise this
And
person cannot-
and the second part is, so far as area is concerned, before that date, it will be the Urban Water Supply Sewerage Board will be paying. And then we'll clarify if the government doesn't want. We'll say that from today, the controlling authority, disciplining authority, and all will be the commissioner of Silchar Municipal Board. From the date when your services were handed over to them. Why the writ petition should be kept pending then?
Yes, yes. Let them come within 15 minutes. They're just playing with the records, Mala.
It's
Nothing
okay. He's only showing us what he has been instructed,
Instructed, Mala.
correct? So if the
Well, there
instructions
is
are
no
wrong,
Instructions, I'm sure that the employees are responsible for not regenerating it. This
no,
generation
we'll
of
take it.
Bengal-
You see, when the law officer of the department is making a submission, we'll take it that he has instructions.
No, not to that extent. Then, if he records it, it is good, man. Then there are so many responsible officers will come in. What responsibility has been given to them and what has really been attributed by.
No, doesn't help anyone except for the, what you call, that I was in a receiving end by the disclosing of mind when a particular news went. When a news channel started, what do you call, airing my comment.
I know, yeah. That is, I understand. Well, let him come.
They
Either
they are
today or
expecting the
tomorrow. Mala.
affidavit
Huh?
filed by the department now.
Where is that?
One affidavit filed by the government law.
By the Silchar Municipal Board.
No.
Then?
It's Department of Housing and Urban.
Yeah, finance department has said nothing has been received from the sewerage.
What I'm referring for the senior.
Where is it?
By the respondent number
Department has
one.
filed affidavit.
Yes.
Yes, what does it say?
I kindly see the reply to the paragraph 8.
Reply to para 8 is para 3. Para 3 says that as per so and so, it has been handed over. From which date? Just why I said you can go out and have a discussion with your authorities and tell us.
My instruction is concerned, Lordship, as per direction of Additional Chief Secretary, Department of Housing and Urban Affairs. File number so and so, the Silchar water supply scheme was handed over to the Silchar Municipal Board with man and materials along with the liabilities by letter number so and so, 14/3/2022.
14,
3/2022.
you are reading from where?
I'm reading the letter actually. Just now I received.
Finance department affidavit is there. Finance department affidavit.
No, he's saying from a particular date it has been given.
So your lordship will find that in the rate petition, page 25, paragraph 8.
Page 25, para 8.
Right. Okay, yeah. You are the main person who should speak.
Finance department, paragraph 4, your lordship will read.
14/3/2022. Now, so we'll direct the government to issue a letter saying that from this 14/3/2022, the current salary will be released by the, they will be treated as employees of Silchar Municipal Board. And the salaries from that day will be the liability of Silchar Municipal Board.
Lord, your lordship can see our affidavit at paragraph 4, page 128. I think this is our affidavit, just we have filed, my lord, Friday.
Friday.
I have given an extra copy.
Yes.
Page 128, paragraph 4.
Yes.
Lord, in view of this, your lordship has seen, there is some deficit all the time to come.
No. You see, I have a different set of questions when I'm addressing you. Now you tell me, asset is vested with, let us say, the example which I can explain very in a better manner. Let me take that example. X has bestowed upon Y a property by way of a will. Correct. Along with that, there's a liability to be paid in respect of that property. So then what comes in is the principle of election. The man who is receiving a gift with some liability has a right to elect. He may refuse to take a property bestowed on him if it contains a liability. Correct?
Can your lordship say that it's a gift? It's all liability.
No, I don't know. You see, this is an example
If
which
it
I
is a
can.
gift, my lord, we always welcome.
No.
Because it's not a will after all.
No, this is a will of the government. The government by its executive fiat expresses his will that from today onwards, this property is vested with Mr. Datta.
My lord, can I say no to my boss?
Why not?
Ultimately is that.
Why not? Why not? It's a democratic republic.
What is happening now, the elected government is not there. Now, if had there been elected chairman, he could have said all that. Now, he is the person directly, my lord, in chain with them.
So
Now, the
therefore,
order comes from there, you have to do that, you have to file this affidavit.
it's
So
okay.
what I am facing, my lord, what argument I am making, it is a half-hearted argument. What I want to say, I am not in a position to say.
My lord, only one.
No, that's
paragraph I would
okay.
like to
No,
say.
Mr. Datta, we are not putting you to a bad situation. Or we are not, what you call, asking you to say anything which you disapprove. But but taking into account your stand in the affidavit, the petitioner stand, 14/3/2022, the property is vested with you.
My lord, that part is
So-
correct.
That part is okay. Then you see the question of the second part is, which is a part which I have till now not made any statement. The property is vested with you in form of a water supply scheme. So therefore, now you cannot segregate the water supply work as an independent work which has a separate entity. Because once the property is vested with Silchar Municipal Board, it becomes an integral part of the asset of the the Silchar Municipal Board.
Very correct.
Therefore, you can't say that the scheme is not sufficiently generating any income, and therefore I will not pay the staff. Because then their what you call their liability to pay their salary would be vested on the fund of the municipal board. Their services are charged to your fund of the Silchar Municipal Board.
That's the reason, my lord, very initially I have said, your lordship, give us some time. I have already intimated them the chart given by my learned friend. Let them work out how they can.
No, that will be necessary, I think. In here, the
It's okay, but-
affidavit filed by the finance minister. That paragraph 4, may I just read that?
Huh?
Paragraph 4 of the finance department. That is important.
Okay, please read.
This time. Finance department affidavit, they, I think I got a copy now. Huh? Well, I'm giving my.
No, it's
copy.
okay. You just tell me we have a copy.
Yeah.
Just tell me.
No, this is paragraph 4, madam.
Just show it to me.
Paragraph 4. So the commissioner of the sewerage board has to take up the matter with the finance for the sorting out of the matter. That with regard to the statements made in.
No, this, the authorities will not help. It will be only under the chairmanship of the chief secretary if the matters are done.
Yes.
Then only it will go to a
Yes, yes.
quietus. Otherwise,
That
this
will
will
be
not.
That manner. Your lordship will see the what they have stated.
Yes.
With regard to statement made in paragraphs petition, the deponent begs to state that since the Department of Housing and Urban Affairs is the administrative department, to clarify the liabilities of the petitioners, the authorities in the finance department by letter dated 9/8/23 communicated the same to the authorities in the Department of Housing and Urban Affairs. However, since the details of the present status of the case have not been furnished by the Department of the Housing and Urban Affairs, the authorities in the finance department are not in a position to clarify their stand. So on that, my lord, your lordship have to give them some time and come back within a week or
This
so.
will not happen. This is unheard of.
They have done, this is what they have done, my lord. Urban and Water Sewerage Board has not taken up the matter with the finance department. That we are sending it, this will be the liability. this
No,
will be-
you see, that's not necessary because of the fact that it's an executive decision of the state. They have somewhere referred that it was directed by the chief minister.
Yes, it is there.
So therefore, the highest executive, what you call the implementing authority
But
of
the
the state has
finance
taken a
matter-
decision.
Financial matter is there, well, finance matter is there. So there any deficiency in the Silchar Municipal Board, it has to be recouped by the government of Assam only, by the finance department.
No.
Then
No,
from where they are going to pay, even if your.
you see,
lordship
that's,
passes an
it's very
order-
simple. That's what I am saying, that is the first statement I made. It will be the grant in aid which the municipal board will have to charge on the state government and get it under the provisions of 243Y.
Yes, well, so therefore, well, the municipality board will have to give a, but from the date, which date the responsibility is with the municipality board. And which date, the sewerage board, that will have to come with.
That's what I'm saying. They'll have to charge it to your salaries will be to the fund of the Silchar Municipal Board.
Not
The,
all, but some
No, from the date 14/3. That municipal act says municipal fund. Which is that provision?
58.
58.
And the before that, sewerage board has to pay us, pay the.
But that they need to pay, so therefore,
Should be direct them to pay within a period of so. Or give them a chance to take up the matter with the finance department, as has been sought by the finance department.
consider municipal fund. You're right. So once it is that, all sums of the state government is sanctioned grant away, that is the provision.
Yes.
So whoever takes the responsibility, ultimately the government will be paying, they will be.
We are
they-
concerned with the salary department.
Yeah.
Other parts are also important, my lord. Who will be our employer, who will be looked after, all those things are very important. Which has to be sorted out by the.
Somebody
department.
must be your employer.
Well,
Somebody has to be your employer.
so I think, my lord, in the. facts
Mr.
and
Nayak,
circumstances-
I think in the fitness of things, let the meetings be held under the chairmanship of the chief secretary. Otherwise, these things are not going to be resolved.
With my humble submission, Lordship, that meeting has already taken place, Lordship. Let us only, what is the resolution of that meeting, Lordship? That much only you have been brought, bring it to the record of this. That much.
It's all right.
Is the only, it is the submission of my learned senior colleague. Let us have that.
So
in-
we are fixing this matter next on 25th August. You have sufficient of time. And this queries which I was making, I reflect in my order so that you take a definite stand as to the date on which whether on 14/3 assets were handed over and the salary and other emoluments to the staff of the water supply scheme will be bound from that day. Correct?
And how can this be paid? Man? When this amount can be paid? They are in very difficult position, man.
See,
Lordship is speaking on 25th. So we can sort out by that time ourselves.
yeah, possible. Yeah, possible.
Only thing, my learned friend is the king here. He is the person, he is our guru. He can sort out everything.
I will try that. Definitely.
No, you see, finance can't do anything. Because it is ultimately it will be the decision of the government in what you call in saying so. The finance will be the only authority because if it goes to finance, the first question is that the finance will say about the what you
In
call.
my understanding, finance department has filed that affidavit only for the purpose of obtaining instruction from the concerned department, nothing else.
No.
They are only trying to know what is happening for the purpose of furnishing instruction.
No. You see, for that you don't need that affidavit to come here. You don't need the order of the court to get instructions. Because if we
My friend was a bit scary, Lordship may pass adverse order, that is why he filed the affidavit. That is the only reason for filing that, nothing else.
No, because if somebody is not getting a salary and there's no clarity as to who will be getting the salary when.
That's true, my lord. It's very.
But their status is not known. What is their status? Suddenly you will throw them out.
That's we will make that clear, Lordship.
Mr. Nair,
My lord, I was not troubling the issues which have been raised. My lord, Silchar has been handed over. But whereas our concern, Hojai, Lonka, these projects have not been handed over and there is a status quo order with regard to a service condition dependent. And urban board is paying us, my lord, whenever they wish. 1 month they pay, then 3-4 months they don't pay. We get a very paltry sum, my lord, 2,000, 2,500, 1,000 like that. Now, my lord, the whole issue is here, my lord, page 148 of 7586. So my lord is asking them to take instructions. My lord will also factor in this part. 7586 2020. My lord will have 148. My lord had been referring to the decision of the highest executive. This is the decision. 148. My lord, this is the minutes of the meeting held on 14/5/22 at so and so office at 3 PM Amrut Mission and projects under so and so survey. Now, my lord, the relevant to this is 149 clause 2, my lord. My lord has got it. The monthly revenue collection of so and so is 68 lakhs, whereas the expenditure is approximately 112 lakh per month. The revenue deficit for running the water supply scheme is so and so. It was decided that ASU shall partially hand over the balance schemes to the ULBs, where electricity bill, chemical and maintenance bill shall be paid from the 15th FC tight fund grant by the respective ULB. And this is important. And wages and operations can be done by AUWS and SB. That's the undertaking by AUWS. Now, my lord would come to page 153, madam.
Just a moment. No, but you see the balance scheme, I don't understand. We have
My
to,
lord,
we have to clarify.
It will be clarified. My lord will come to 153.
Yes,
This is the notification, madam, 21/6/22. In pursuance to the decision taken in the meeting chaired by Honorable Chief Minister so and so, on so and so, the urban water supply will partially hand over the running of these schemes to the urban local bodies, and concerned local bodies will bear the cost of electricity bill, chemical and maintenance bill of such schemes from the available fund under FC tight grant. And ASU will continue to operate and collect revenues until these schemes are fully handed over to the ULS. Now, maybe in Silchar it was fully handed over, but in the others, my lord, it has not been handed over. So, in terms of this decision, in my lord, sputters, my lord, whenever they feel, they distribute, dole out some amounts to us. So, the decision with regard to this thing is the Assam Urban Water Supply and Sewerage Board will have to bear the burden of our salaries. And Lanka Municipal Board had refused to take this up because of this revenue deficit. Jorhat and Silchar have been instructed, my lord, have been handed over. The rest is still. So, my lord would have my lord is asking them to have the instruction in the other matters. My lord will have an instruction, ask them to have an instruction with the other boards also, so that a picture is clear before your lordship, because I'm not in a position to supply that information upfront, my lord. But if this is the decision, and it's a decision which you are applying, then, you know, until and unless you cannot show that you have handed over the total scheme, the urban water, our parent body is liable. And in my case, there is an interim direction that my service conditions as existing should not be.
then there are two orders separately.
Two.
One will be in
My senior's case, my lord, Mr. Vinny Das.
Das's case will have separate orders.
36, yeah, what even?
That is 1989. In 1989, you say. The names are there in this last order. Excellence. 31/7/23 order. Let's go. It has been submitted at the outset that the respondent number 1, respondent number 7, and respondent number 9 have respectively filed their separate affidavit in oppositions. Said affidavits are not on record. The registry shall track and tag the said affidavits on record. Next. The Emphatic submission of the subpoena act and then standing counsel for the finance department
I'm appearing for 1 and 2 laws.
for 1 and 2. Okay. Who is 1 and 2?
Department of Housing and Urban.
Achha, for respondent numbers 1 and 2 has submitted that the Silchar water supply project under capital AMRUT has been handed over to the Silchar Municipal Board along with men and materials on 14/3/2022. So, in the said context, Mr. S. Dattal and Senior Counsel appearing for Silchar Municipal Board has submitted that that as per stand taken in their affidavit in opposition, there is a deficit in the earnings out of the Silchar water supply project, which is creating an impediment on part of the Silchar Municipal Board to pay salary and other emoluments to the petitioners. Next paragraph. The learned senior counsel for the petitioners has submitted that in this case, without any clarity on several issues, the authorities of the Silchar Municipal Board and the Assam Water Supply, Assam Urban Water Supply and Sewerage Board have not been able to clarify as to the status of the petitioners with regard to their employment, who would be their appointing authority and disciplinary authority, and who would be their the authority from whom they will be receiving instructions to work. So accordingly, it is suggested that unless appropriate decision is taken in the appropriate executive level with in the presence of the Chief Secretary to the Government of Assam, there are certain issues relating to the employment of the petitioners which cannot be ironed out. Next paragraph. In this regard, the learned standing counsel for the respondent numbers 1 and 2 has submitted that as per his instructions, some meetings have taken place between the authorities, amongst the authorities, and he may be permitted some time to bring on record the decision taken by at the executive level. Next paragraph. It privacy appears from the submissions made at the bar that if the Silchar water supply project has been handed over to the Silchar Municipal Board with effect from 14/3/2022. The respondents are required to bring clarity to the point as to whether from 14/3/2022 the liability of salary and emoluments to the petitioners would be borne by the Silchar Municipal Board with effect from 14/3/2022. And the respondents are also required to bring on record as to whether the Assam Urban Water Supply and Sewerage Board would be taking up the responsibility of clearing the dues payable to the petitioners prior to 14/3/2022. Full stop. The second point on which clarity is required to be expressed by in which the respondent should clarify is that is in the absence of any clarity, whether it would be the who is the head chairman? Silchar Municipal Board,
Executive officer.
whether the chief executive officer,
No, only executive. officer.
whether the executive officer of Silchar Municipal Board would become the disciplinary authority, appointing and disciplinary authority for the petitioners with effect from 14/3/2022. And what more, Mr. Das?
The area salary part also.
At least I have already noted. They'll have to clarify whether from before that 14/3.
Yes.
Next para. Moreover, the authorities are also required to clarify the
Chief Secretary
time frame within which they are proposing to pay the salary and other emoluments payable to the petitioners.
The chief secretary will supervise the matter.
No, I'm just giving it in your mouth that you are suggesting that it should be
Yes.
taken in the presence of chief secretary. And in response, he says that we have taken a decision, we will be producing it.
That your lordship records can get.
That's why I'm recording it. Next para. It's okay? Next,
One thing, my lord, my learned friend should tell his client also to do the work regularly. They are not working, they're skipping.
No, you see, Mr. Datta, you know it very well. Not to speak of others, it happens even to the junior colleagues you are employing. If you don't get them the responsibility, you don't know whether tomorrow, today at 4 o'clock when your matter is standing up coming up in a court, which junior will be present to represent you, you don't know.
That's true.
So therefore, you see, unless there is a clarity on the point, it is very difficult to handle things. Because if I know that I am not getting my salary, why should I put in the real effort?
That might be the reason also.
And second is that when you are getting salary for not doing the work, why should you work at all?
That we understand. The practical aspect of the matter.
No, not practical aspect. Because you see, there's something I don't want to be in the public domain. Next, the affidavit in opposition we filed in course of the week. List on 21/8/2023.
And obligations.
Time for the petitioner number. Today's service report regarding respondent number 2 and 5, my lord. Lordship may previously order dated 6/8/2020 flag A, my lord.
Where is your affidavit?
Give it, my lord.
You're for
Respondent 1, 3, and 4.
1, 3, and 4.
Yes.
And Mr. Saikia, counsel for the petitioner. And Mr. Edeka, I'm sorry. Then the counsel appearing for respondent number 1, 3, and
4.
4. Next para. It is noted that the petitioner has taken steps thrice for service of notice on respondent numbers 2 and 5. One by registered post with AD, one by process server, and the third by way of Dasti. Next para. Insofar as number 5 is concerned, as per order of the Lahosima Court dated 5/1/2023, postal notice on respondent number 5 has been returned back With postal remark not found, return to sender. Postal. Steps was again taken. By registered post on 6/2/2023. And once again, the postal notice has been returned unserved. In respect of respond number 5 with remark, addressee always absent, so return to sender. The process server, as per office note dated 26/5/2023, the process server could not. The process server from the court of Munsif number 1, Barpeta, could not serve notice on respond number 5, as said respondent was not found in the given address. Full stop. In the affidavit of justice service, might has been said that respondent number 5, and that no one from the respondent number 5's house came out to receive the notice, and accordingly notice could not be served. Full stop. In view of the nature of attempts, in view of the number of attempts made by the petitioner to serve notice on the respondent number 5, it can be the court is inclined to take to accept that the notice on respondent number 5 is deemed to be duly served due to his by taking a presumption that it's presumed to be duly served as the respondent number 5 is avoiding service or notice. Next, insofar as the service of notice on respondent number 2 is concerned, procedure postal process issued on respondent 2 the issue was neither the AD card nor the unserved notice has been written back. The usual process related to the process server of Munsif number 1, Bogota, was not served, could not be served on respondent number 2 as he was not found in the given address. As per the affidavit of the C, comma, the respondent who had refused to accept notice. Therefore, the notice on respondent two is due to be duly served on his refusal to accept notice. On her acceptance, which. Accordingly, the case is ready as regards service. You're filing an affidavit, Mr. Decker,
Within 2 weeks, I will be filing.
2 weeks. The land council for the respondent numbers 1, 3, and 4.
Yes.
Praise for them is granted 2 weeks time to file affidavit in opposition with the matter. This after 2 weeks.
Gotcha.
Please, the lordship. In this case, lordship, there is a direction of this honorable court on 2012-2021 for reinstatement of the petitioner. On the ground of correction of his date of birth. And accordingly, the direction was given to the petitioner also to take to submit representation, and that was duly served. And after this representation was submitted before the.
No, your the department doesn't match. Respondent number 1, where did you send notice?
Response number 1, lordship, this is Commissioner Secretary.
And its statement is that the department doesn't match. You ask somebody from the health, what is the correct department?
On the last occasion, lordship, I had handed over one communication that was received from the Director of Health Services, Assam. With regard to after this judgment was pronounced, lordship, there was a communication to the government to take a call with regard to the correction of.
No,
date of
you
birth.
see, this is a contempt matter.
Yes, lordship.
You have issued notice on one Siddharth Singh.
Yes, lord.
The notice has been returned back on the ground that refuse for department doesn't match RTS. Is Mr. Siddharth Singh still the Commissioner Secretary Health?
That I had to take the instruction.
That's
But
why it
the
is
last
written back.
occasion, lordship, the standing council had appeared for the.
No, ask their standing council, there are 2 or 3, you ask someone, they will be able to tell you. This health, who is there? I go outside and find it out. After some time,
Yes, lord.
you find out.
That is your lordship.
Yes,
My lord, order dated, my lord, 27/4/2022, my lord, is yet to comply, my lord. My lord, para 8, my lord, pays, my lord, 18.
has been issued, lordship.
I have not received any money, my lord. That's why, my lord, kindly see para 8 of my lord, page 18, my lord, of the judgment.
then we'll ask the opposition person present.
It is
No,
ought
lordship,
to
it
have
is
been
just
paid on
PPO
since.
has been issued, lordship, on 2/8/2023.
But PPA is issued.
Yes.
If you're not
lordship.
getting it, is something wrong at your end.
Okay,
Give a
he
copy to
can-
him.
Yes, he can collect it from the lordship.
No, give a
and the
copy to him.
Yes, sir. Treasury officer, Kasar, lordship.
Mr. Slam, take instructions, we'll take it up next week.
My lord,
Take instructions. All sides are duly represented. This Didi Burman, the council appearing for respondent number
5, lordship.
5 has produced a copy of
No, lordship, 8, lordship.
8,
Director of
has
Health.
produced a copy of pension payment order dated 2/8/2023, including payment order for the provisional death cum retirement gratuity. So, the copy of the set to pension payment orders have been provided to Mr. M. Islam, counsel for the petitioner, so as to enable him to obtain instructions. Mr. M. Nath, senior counsel, assisted by Mr. A. Bhattacharya, counsel for respondent number
1 and 4.
1 and 4, instance Datta, Council for Respangba.
6.
6 are present. List after a week.
Kindly apply.
A copy of the said payment, pension payment order is kept on the record.
Make this or
Yes.
My lord, in this matter, my lord, we'd like to file an affidavit, my lord, some sort that may be allowed. For respondent number 2.
Have you made the, release the payment? No.
And the payment has been released, my lord, but they disputed the amount by saying that, my lord, the interest is compound interest, my lord. But if your lordship looks at the judgment at page number 22, my lord, 22, the judgment only mentions about 4% interest, my lord. Does not say whether it is simple or
It
compound.
will be simple interest.
Yes, my lord. So by
22.
applying simple interest, my lord, we have already released the check, but they have refused to accept the check, my lord. We have already complied with this order, ma'am.
Yes, what do you have to say?
Lordship, I have filed an affidavit
I have seen that, I have read that.
during pendency of this petition. Respondents have issued a letter in asking to receive the said amount. As per my calculation, the amount should be 6,22,000.
If you start using a calculator, within how much hours your battery will end? A battery has a lifespan.
Yes.
Supposing today you start using a calculator, within how many hours your battery will end? Let us say 1 month,
Yes.
your battery will work. Even if you carry on calculating for 1 month, your interest would not be compounded. Merely because you calculate it, the thing in contempt will make the interest compound. So if you are not receiving, it will say you're not required to pay. We'll decide at the end.
Lordship, may be given a direction as part up to this honorable.
No, till we decide, we'll fix this matter for hearing. Until we decide, we'll say that the interest will not continue, and your payment will also not be released.
My lord, by order date 17/2/2023.
You're not getting your payment till we hear the matter.
They issued a letter just to collect so amount. I have
That's why you don't collect it. We'll decide your entitlement for 4% compound interest.
yes, I will receive. Maybe given a check.
Then why you are permitting this?
My lord,
Yeah.
on 17/2 itself, my lord, the honorable court directed him to receive the check, but he did not comply with that order, my lord. The check was released long back.
What is the amount?
My lord, total amount will be, my lord,
No, 3 lakh, how much is the principal amount?
my lord, 4,46,000, man.
Principal amount is
4,46,000.
446, 4,46,000.
Yes.
From,
From 2014.
from which date to which date he is entitled to interest?
And then from the date of filing. My lord, may I submit the calculation sheet of our office?
Show it to me.
1/8/2014, from
1,
8/2014.
the check is of which date?
14/2/2020.
14/2/2023.
14 to 23.
23.
You know, you'll have to pay some more additional interest. 24 to 23.
14/2/23.
Hmm?
Check date, 14/2/23.
No, you gave it to petitioner on which date?
My lord, he was asked to collect on,
16 to you gave a letter.
16.
on my lord, 16/2.
16 to.
Yes,
So till 16 to you'll have to pay interest.
my lord.
16 to 23. Interest between 22/6/2022.
To 16/2/23.
It will be from 23/6/22. So for this 8 months, you'll have to pay interest.
My lord.
Heard Mr.
Yes, Burman.
S.
Burman.
Burman, counsel for the petitioner,
Yes, that's for
and
respondent.
Mr. S. Das, the counsel for the respondent.
Number 2, my lord.
Number 2. Next paragraph. This contempt petition under section 11 and 12 of the Contempt of Courts Act read with Article 215 of the Constitution of India has been filed alleging non-compliance of order dated 8/6/2022 passed by this court in WBC 3909 of 2014. Next paragraph. From the as per the said order, comma, the court is held the petitioner to be entitled to outstanding salary to the extent of rupees 3,50,902 and rupees 95,112 towards
Balance dues, my lord.
balance due. And they said total dues of rupees 4,46,014 was ordered to be paid, along with interest at the rate of 4% from 1/8/2014. Full stop. Next paragraph. From the contents of the additional affidavit filed by the petitioner on 23/3/2023, the petitioner has admitted that the managing director of Assam Small Industries Development Corporation Limited had issued a letter dated 16/2/2023 asking the petitioner to collect a check for rupees 5,86,791 which was not received by him. Full stop. According to the learned counsel for the petitioner, the that on the principal sum of rupees 4,46,014, interest of rupees of 4% was to be paid at annual rests, and therefore by compounding the interest on yearly basis, the petitioner has computed the principal with interest at rupees 6,22,642.89. Full stop. Next, but according to the respondent number 2, 4% interest on the sum of rupees 4,46,014 from 1/8/2014 to 22/6/2022 would be rupees 1,40,777, and accordingly the petitioner would be entitled to a sum of rupees 5,86,791 as on 22/6/2022. Full stop. Next, in this regard, the court finds that as the offer for collecting the check was issued on 16/2/2023, the petitioner would be entitled to interest from 23/6/2022 TO2 16/2/2023, apart from the principal and interest up to 22/6/2022 being rupees 5,86,791. Full stop. The order of this court giving direction to the respondent authority to pay 4% interest cannot be read to mean that the interest was to be calculated on yearly rest. Stop. Therefore, the action of the of the petitioner to not receive the check for rupees 4,86,791 was in his own peril. Next time. Next para, accordingly. If the petitioner so desires, he may apply before the managing director of ASIDC Limited. Or you'll give him a check tomorrow?
ma'am.
By when you will give him a check?
I don't, within next 2 weeks, man. 15 days, man.
15 days.
Yes, ma'am.
So we keep it pending till then.
Right.
We are not closing it. Next para.
My lord, if that check amount will be, my lord, reviewed, my lord, then my lord, we have to issue a fresh check, my lord.
Yes, definitely.
Yes.
Otherwise you want to pay, give him a still check.
Yes.
Then we send you to jail from here.
So, my lord, 15 days time will be, man.
15 days time. Huh? But if you want to give him a still check, you are welcome. Because then at least in my career, I would have sent somebody from here to prison, civil prison. Yes. Okay. Next, the Learned Counsel to the petitioner seeks 15 days time to prepare the check and make payment after courtly formalities. So accordingly, release this matter. 15 after 15 days, give a date. This matter will transfer.
File your place.
Sure, item number 46, standing council for the health.
Health is there. Yes.
Lordship, so far as I remember, Lordship, there was a direction in the writ petition while it was disposed of to the petitioner to file a representation before the Director of Health Services, Lordship. Lordship, here, Lordship, the current incumbent has not been made a party, Lordship. So it is
No,
difficult
this,
for us to
this,
file.
this officer Siddharth, he is no longer the,
No, the direction was issued to the Director of Health Services.
no,
Lordship.
no, he's, no, the notice on respondent number 1 has come back on the ground that no refused for department does not match. Now the respondent here, number 1, is Siddharth Singh IS.
Yes, Lordship.
Is he still there?
No, Lordship. And not even Lordship, respondent number 2, contender number 2.
He,
3, Lordship, I'll have to check, Lordship, Joint Director of.
so
Health
1 and 2 are
Services.
not there.
Not there. And Lordship, moreover, Lordship, there was a direction to the petitioner to file a representation before the Director of Health Services, Lordship. I had received this instruction way back in 2/3/2023, Lordship. Lordship.
No, yes, next copy of the. Yes, next copy of the representation.
But no seal, nothing, Lordship, and we say that we have not received. the
Lordship, this is
officer's-
the thing, on the last.
Lordship, Lordship, may I place the instruction? May I read the instruction which I have received, Lordship? I placed it before your Lordship, Lordship. Lordship, with reference to the subject cited above, I have the honor to inform you that this directorate has not received any representation in accordance with the order passed by the Honorable Guwahati High Court in WPC 2307 of 19 dated 2012-2021. However, the undersigned has submitted a proposal to the government with a request to give instruction on the matter regarding correction of date of birth in the service book in respect of Sri Chandrababu Das PMA by Directorate Letter so and so dated 8/2/2022, who had already retired from service on 28/2/2019. Lordship, after receiving a letter from the Standing Council, Health and Family Welfare Department, Government of Assam. Lordship, when it was disposed of, Lordship, the Standing Council has Lordship has furnished a letter, Lordship, stating that this matter has been disposed of with so and so direction, Lordship, but we have not received any, Lordship, representation, Lordship, so how can there be a contempt, Lordship?
Lordship,
We have to receive a representation. Lordship.
the copy that has been annexed with the writ petition, that particular copy, the seal is not there, but I'm having a copy where the seal of the department is very much there.
Okay.
Yes. And the
This lordship, I have to take instruction whether it was,
on the
and
last,
lordship, if he has this copy with seal, how can that copy do not have a seal, lordship? It may be manufactured, lordship.
no, this is absolutely not manufactured. but I'm
From where, lordship, he got that copy, lordship?
Which one?
The
The
one,
extra copy that was I'm having. Because on the last location, there is a award
Instructions.
specific
Yes, lordship.
statement with regard
And
to
lordship,
that.
in the meantime, lordship, our.
Just a moment.
On the last location, lordship, this I have furnished one document, one communication from the side of the Director of Health Services. And based on that particular communication, the notice has been issued to the contaminants. Lordship, kindly peruse that particular communication, which goes to show that the contaminants are very much aware about the direction of this.
Yes,
whole
lordship,
code.
we are.
But your representation must be there.
And that is the reason why on the 31st of December, lordship, probably December, the representation was submitted and there is a seal with regard to that. Now the seal and the representation is very much there in view of that.
Let me see that.
They are supposed to take the, they're supposed to take the call with regard to the direction of this honorable court. And
No,
pass
no,
the
you
speaking
see,
order.
even before you make your submissions, he has already produced a letter of 2/3/2023 that
Yes.
representative is not received.
Exactly, lordship, because
It's not that after receipt of this notice, they are showing that.
no, but the thing is that this particular letter was there with me.
But lordship not annexed.
Yes, that was not annexed, but this particular letter.
No, no,
was-
instead of that, you say
Yes.
the notice was issued here on 12/4/2023,
Mm.
And
right? But before that, they have 2/3, they have prepared this letter. They could not have done if
Yes, lordship.
they had no intention to comply with the order of this court.
We on our part has already moved.
Give a photocopy of this to him,
Yes,
he'll
sir.
be able to track it.
Because this particular document was written by the petitioner. And since
It's
at the time
okay.
of filing
We are-
of the contempt, since I
We
was
are
not
not,
having
we are
that
not,
copy.
we are.
Because the specific statement is there in my contempt petition. also,
Give a
lordship.
copy to him.
Yes,
You
yes,
want
I
your
will
things
give
to be
copy.
done. You don't want this to be heard after
Yes,
5 years.
Yes, no.
And lordship, moreover,
Give a-
lordship, he will have to impede lordship the current incumbent lordship. Otherwise, lordship, we have received the wakalat number, but we are unable to file the wakalat number. And that's why you have missed the matter lordship today.
Uh,
First page to give him, or what to give him?
Give first page to him,
Yes,
he'll take it. It is in the notice on respondent number 1
And two.
has been returned back with a remark refused for department not match RTS, inverted commas, refused for department not match RTS, MATCH, match RTS, capital RTS. Inverted comma closed. Full stop. Accordingly, moreover, neither ID card nor answer notice on respondent number 2 has been received back. So there's no office note with regard to the service of notice on respondent number 3. Next one. Mr. D. Upamanian, Leonard, standing counsel for Health Department, who was present, has been asked to inform as to whether the respondent numbers, the respondents are still in the consent post. Accordingly, he submits that insofar as the respondent numbers 1 and 2 are concerned, they are no longer respectively holding the office of Commissioner and Secretary to the Government of Assam, Health and Family Welfare Department, and Director of Health Services Assam. So he submits that he has to take instructions as to whether respondent number 3 is still in the consent post. Next one. The learned standing counsel for the Health Department has submitted that as per instructions received by him, the representation of the petitioner was not served on the Director of Health Services. The learned counsel for the petitioner has produced a copy of receipted copy of the representation dated 30/12/2020 2022. Stop. There are photocopy of the same.
31/12.
31/12/2022.
21.
21.
20.
Stop. There are photocopy of the said representation. Disclosing the seal and signature we provided to the standing counsel for the health department so as to enable him to obtain instructions.
And compare with.
Next one. Meanwhile, the learned counsel for the petitioner shall take note of the submissions made by learned counsel for the learned standing counsel for the health department that respondent number 1 and 2 are no longer holding the said post. Provide a name, their names to him.
Siddharth Singh is the Commissioner and Secretary, Health and Family Welfare, B Department, Lordship.
No. Now who is the
For A, Lordship, we do not have anyone, Lordship. It's a B Department, Lordship, he is there, but we have two departments, Lordship. One is Health and Family Welfare A Department and one is B Department. Lordship, here it is written as Health and Family Welfare Department. Lordship, it is B Department where he is the Commissioner and Secretary, Siddharth. And Lordship, the Director of Health Services is Dr. Neil Madhav Das.
No, I don't know. You see, if your own officers don't know, this is A and B happened when?
Later on.
Lordship, it's there, Lordship. Lordship, since Lordship 5-6 years. Lordship. It's there.
Look at this letter. Letter is written by whom?
Director of Health Services.
Director. And he does not know who is his department. He is writing to Director of Health Services.
Lordship, it is the Principal Secretary, Lordship. He has written to the Principal Secretary, Lordship.
Of which department?
Health and Family Welfare Department.
Then if you say there is A and B,
Lordship, Commissioner and Secretary, Lordship. Principal Secretary is the same. But Commissioner and Secretary, there are two different posts, Lordship. For A, there is one person and for B, there is another person.
oh, acha.
So he is, Siddharth Singh is Health and Family Welfare B Department.
This should go to whom?
A, Lordship. Lordship, I'll get the name, Lordship, and Lordship for.
Give it to Mr.
Yes, Lordship. Yes, Lordship. And Lordship,
Okay.
Director of Health Services is Neil Madhav Das, Dr. Neil Madhav Das.
You just take note of his submission.
Yes, Lordship.
The Learned Counsel for the Department Counsel to provide the name of the incumbents to office of respondent numbers 1 and 2. Next one, the pendency of the representation shall not be a bar for the respondent authorities to dispose of the representation of the petitioner, a copy of which has been provided to the Learned Standing Counsel for the Health Department. This after a month,
Yes, Lordship. In the meantime, Lordship.
we have to make a file application for amendment
For
for correction of the names.
For correction.
I'll provide them.
Can a date be fixed, Lordship? Otherwise, it's a. whole
You're
thing.
fixing it after a month, you'll have to file an application otherwise also. Fixing a date would not matter to you.
Yes, yes, Lordship.
You give a photocopy to him.
Yes, I'll give
Lordship,
it.
I'll provide him the names. Lordship. Highly appreciate.
May I please, Lordship? I am appealing for response 5, 6, and 7, Lordship. We have prepared the affidavit in opposition, Lordship. Because my kindly grant us 10 days time, Lordship. We have asked our concerned official to come to swear this affidavit.
Okay, 10 days time.
Yes. Also, another aspect, Lordship, in this case, Lordship, stand of the respondent full is crucial. Though the Lordship court has presumed the services upon the state respondent is deemed to be served. But Lordship, I think because they have stated that they have not issued the state certificate, Lordship. And on the basis of the report received from the concerned respondent full, Lordship, the ADC has wrote us later dated case 54, Lordship. And accordingly, on the basis of the state letter, Lordship, respondent number
50?
54, Lordship.
So, yes,
Which refers to the subject quoted above the letter under reference regarding reconfirming the authenticity of the caste certificate issued to see Amit Das, so and so and so. It is informed you that as requested to report was sought from the chairman subdivision scheduled caste development board. So they have hide this for further verification of the caste certificate issued by the board to the aforementioned person. In his report, the chairman has clearly stated that the certificate was not issued by subdivision scheduled caste development board. But as per the record of the office that is in the issue register of this office, it is seen that during that particular period, no such certificate was issued from this office. Therefore, probably the certificate may be fake certificate. So stand of the respondent code is essential. Because
Yeah, right.
we have accorded in terms with the appointment letter, Lordship.
You serve notice on respondent 4 by Dusty then, otherwise you will be in trouble.
Yes, Lordship. That will help.
We
them,
can't, with this, if the respondent 4 does not appear, you will be the sufferer.
Yes, that will help the
Ah,
person.
yeah, you're right, Mr. Kalita. Learned counsel for the petitioner and respondent number 5 are present. Sorry, government is also there.
Lordship, 5, 6, 7.
Rules for revenue,
Yes, Doctor.
you'll be there.
Yes.
Mr.
Yes, Doctor.
As Datta, serially right. So, how do you say?
HK Sharma.
Yes, Sharma, counsel for the petitioner. Mr. S. Datta, learned standing counsel for the revenue department appearing for respondent number 1. Mr. C.K.S. Barwa, learned government advocate appearing for respondent number 2 and 3. No, 4 is you can't appear. And Mr. K. Kalita, learned counsel for respondent number 5, 6, and 7. Next para. The learned counsel for respondent number 5, 6, and 7 has submitted that has prayed for and is granted 10 days time to file affidavit in opposition in the matter. Next para. The learned standing counsel for learned counsel for respondent numbers 5, 6, and 7 has referred to annexure Roman 9 of this writ petition and has submitted that it is as per the report of the subdivisional Scheduled Caste Development Board report that the additional deputy commissioner, development board, Sadia, that the additional deputy commissioner in charge Sadia subdivision had issued a letter dated 25/5/2022 stating that no caste or that the caste certificate in reference was not issued by them. Accordingly, it is submitted that it would be in this regard, it is submitted that as per order dated 18/1/2022 of the Lahozima Court, 23 by the Lahozima Court, service on respondent number 4 is deemed to be duly served. Accordingly, it is submitted that without the stand of the respondent number 4, it would be the petitioner would be highly prejudiced. Next para. Accordingly, as the submission made by London Council for respondent number 5, 6, and 7 appears to be logical, the logical and acceptable, the court is inclined to direct the petitioner to serve notice on respondent number 4 by way of Dasti. By routing the process through the registry of the court and upon service, an affidavit of service will be filed prior to the next date of listing. Notice is made returnable on 25/8/2023. List accordingly. Yeah. Mr. Kalita will be able to file their affidavit by then, 25/8. 15. Oh, I'll have to rise. This will be the last matter. I have to go there. I'll not be able to take up any other matter. There's tomorrow's preparation, I have to go and oversee. I just forgot about it. This is item 50, yes.
My lord, the prayer of the petitioner for compassionate appointment, that was rejected, my lord. The rejection is at page 73.
We'll take it up next week.
My
Monday.
lord,
Well, I won't have time today.
my lord.
List on 21/8/2023. Your, the affidavits are there?
Affidavits are not.
Huh?
Inside that DLC has not taken care of the clause 15. That's the issue,
Clause 15.
clause 15.
Okay, then I'll pass orders on Monday. But today, I'm sorry. Several people will be there. House function.